test, check 1 2, test, check, hello, check 1 2, test, check, hello.
people panic. And we had a lot of deaths and things like that. But third wave of COVID, everybody was so educated, so well informed. They didn't rush, they didn't panic, they didn't do anything. Why? Because they had information. They had information how to handle themselves. They treated it like another cold and a cough. And they took their treatment. Yeah, if it was very bad, they would reach out to a doctor, but then they were very confident that they could handle. We want this movement to reach that place where everybody is aware of the road traffic accidents or fall from heights or any of these neurological disabilities the patients get or the people get, how to deal with them, how to get them to a just compensation, how to handhold them and give them the humanitarian dignity. This is what you're going to hear this few hours from now from all these eminent speakers. So I again welcome all of you. Thank you so much. We can start with the lighting of the lamp. So if I can request all the dignitaries to please head towards the lamp.
Beginning of today's program and the shared intent that brings us all together. Today is not merely the release of a set of books. It is the coming together of conversations that have long moved in parallel: law, neuroscience, medicine, public policy, and human dignity. Now, all meeting at a shared point of reflection. In many ways, today marks the beginning of the Neuro Justice movement. We are deeply privileged to have with us the chief guests and the distinguished dignitaries who have graciously consented to be part of this occasion. I request them to kindly accept a small token of gratitude as we begin the journey of Neuro Justice. May I now request Dr. Sharan Srinivasan and Dr. Pratibha Sharan, authors of the Neuro Justice Trilogy and Handbook, to kindly present a small token of gratitude to the chief guest, president of the function, and the guests of honors. Honorable Justice Arvind Kumar, Judge, Supreme Court of India, whose presence today lends constitutional depth, ethical clarity, and enduring significance to this occasion. We are grateful to him for reviewing the manuscripts and authoring the foreword to the books. Thank you, sir. Honorable Justice R.V. Ravindran, former Judge of Supreme Court of India, whose scholarship and clarity of thought have shaped generations of legal reasoning. Thank you for joining us today, sir. Honorable Justice A.V. Chandrasekhar, former judge of the High Court of Karnataka, known for his integrity on the bench and service beyond it. Thank you for being the pillar of today's program, sir. Dr. V.D. Sinha, former Vice President, World Federation of Neurosurgical Societies, President-elect of the Asian Australian Society of Neurological Surgeons, whose work bridges global neuroscience and ethical practice. We are honored that he has graciously endorsed the Neurojustice books. Dr. Manas Panigrahi, President of the Neurological Society of India, whose leadership continues to advance patient-centered neurological care. He has also extended his endorsements to the Neurojustice books. Thank you, sir. Shri Seemant Kumar Singh, Commissioner of Police, Bengaluru, whose work reminds us of the lived interface between law, behavior, and public responsibility. Thank you for joining us today, sir. Padma Shri K.Y. Venkatesh, Paralympian and Disability Ambassador of PRS Neurosciences, whose life and journey embody the human spirit at the heart of neurojustice. Thank you for being here today, sir. Thank you, Dr. Sharan Srinivasan and Dr. Pratibha Sharan. I now request Dr. Sharan Srinivasan, Chairman and Managing Director of PRS Neurosciences, and author of the Neurojustice Trilogy and Handbook, the guiding force behind the Neurojustice vision and movement, to share a few words on the intent, journey, and purpose behind this work. Over to you, sir.
Namaste, everybody. Thank you very much, all of you, for coming. Dignitaries on the dais, so thank you very much, all of you, for having come and graced this occasion. Today, we are setting one step forward towards understanding functional disability. So I want to turn this around from what we know so far and where we need to be honest and fair in what we are trying to do. So many of you have seen this surgery, a patient playing guitar, when we are able to burn a circuit in the brain. And patient is awake and he is playing his guitar. So for many of you, it was impossible to even thought that is possible, that somebody can be awake and playing a guitar when we do this surgery. Next is this. This is a patient of Parkinson's disease. Many of you might have seen patients like this with hand tremors. And then I'll show you. You watch the tremor of the hand. Sound bartala. Yeah, you can keep on watching the shake of her hand. I'm inside her brain. I'm burning her circuit and the hand tremor stops. That's how amazing it is possible for the brain to be fixed like this. So if this can happen in the OT, why can't it happen outside in the neurojudicial space? So that's what, so something that you will not believe was possible, something you thought may not be possible is the journey I'm going to take you through for now. So let's go through next. So I want to do a neurojustice reset. As you heard, our awareness and education wing is called Rebooting the Brain. So let us look at how to reboot the world about how it thinks about disability, compensation, and justice. It's a very important thing at the end of the day. So to know what is going on. So let's see. So why is this reboot necessary? You all have heard this example of don't give them the fish, teach them how to fish. It's a very common phrase that we use. So I've taken that as an example to drive the point home. If a person can no longer fish, what do? The system has to give them fish for life. That's what the compensation process is all about. Just thinking has shaped the laws and statutes, compensation schedules, insurance underwriting, judicial reasoning, patient and caregiver expectations. Many patients become so lazy, even though they are well, they don't want to work. They think free money is going to come at the end of the day. And medical certification practices. There's a level of resignation, cynicism, and fatalism in this whole process. Why this reboot was necessary is because it was time, it was rooted in compassion, but today it's not complete. Why am I saying that? Because the world has changed. The world is not the same as it was 30, 40, 50 years ago. Human capacity has changed. Technology has changed. Today it's at the tip of our fingers, but our thinking has not yet changed. And that's what I intend to do and we intend to do with this Neuro Justice movement. The mental software disability needs a reboot. And that's where we're going down this path. Let us look at some hidden assumptions. Give them fish for life. Disability is static, functional loss is permanent, it is final at the point of time we assess the patient, justice is complete, and compensation is handed over. Once it is done, there's, it rewards dependency, it institutionalizes low expectations, it does not encourage people to strive to get back to their life, and unintentionally is locking people into lifelong functional stagnation. We cannot afford this, the world cannot afford disability. So the result is, and then the next thing that happens, outcomes are never revisited. Was it really right? Did the patient get better? We have seen so many patients getting better over many years. So it's not that the disability assessment at a point of time is the final disability. We are not focused on enablement, we are focused on disability. Disability is a negative word, enablement is a positive word. We need to flip this around at the end of the day. The systems do not learn exactly what happens to this patient's journey after the award is given. Is it really going to the patient's welfare? Is somebody else following the money? The third party, we do not know what is going on. So the justice is not the intent, it's outdated system design. That's what we are trying to see. And if you look at it, even if it looks humane, what is happening is it's designed to provide fish indefinitely. And we do not want that to happen. We're not asking the question, are we asking whether the function can improve? We have fixed 1 year as the disability point. We have seen patients improving even after 5 years. But there's an artificial line drawn there because of which everybody is boxed into the whole process. If you stop investing in tools, trainings, and environments, and then the enablement stops and the patient is not empowered to get better, like giving a motorized wheelchair for them to go back to their life as an example. We freeze expectations at the worst moment. We stop assessing real-world situations. Can they function in a real-world situation versus in a rehabilitation center or something other place? And that's why we are stopping to learn. The result is a silent tragedy. Families are burdened, people are living below their potential, and the countries can't grow if it is like this. So if you go through the compassion, there's no compassion. Everybody is losing it. Individual is losing, family, court, insurance, society. Eventually the country is losing because we cannot have disabled people sitting around and not contributing. So historically, we need to change this conversation, and this conversation is possible now because we live in a different reality. There's advanced neuro-rehabilitation services available, there are neuromodulation services available, there's assistive technologies available. We have a lot of adaptive devices. Technology enhancements and environmental redesigns are possible, which was not true in the past. We have AI, we have digital things that can help us to monitor, to actually know the last mile connectivity and what is happening, and we have longitudinal outcome data. If we don't do all these things, it's a design failure. So fundamental shift, I'm inviting each of you to think through this process is my humble request, for everybody here and the larger audience who may be listening to this subsequently is, can we move from dependency-based justice to enablement-aware justice? It's a complete shift that I want to do in how people are thinking about this. The cup half full versus the cup half empty. This does not mean withdrawing support, forcing productivity, or denying protection. I'm not saying that. I'm not saying we abandon the disabled, let them go do what they want. That's not what I'm saying. Actually, it's farther from the truth from what I'm trying to say. It means something more responsible. Because many of the people don't want the crumbs. They want to get back to their life. We have to design systems where the people is enabled to recover, re-engage, and participate. As much as the biology allows them to do based on the injury that has got sustained. So coming back to the give fish for life versus to give fish when needed, but continuously asking ourselves the question. The system is asking the question, how close the person can get to fishing again? Can I constantly push that line to see what is going on? This does not mean we're trying to forcing fishing, denying support, or blaming those who can't fish. That's not again what I'm saying. It means that we have to design not just survival, but enablement where the biology permits that. So a new question to the judicial system. When I say system, is not just the judicial system. All of us in the ecosystem who are part of this whole process is, let us reframe the question the courts and insurance are implicitly answering. The question is, how many fish does this person need for life? Or how much money does he need based on whatever he is apparently losing? Or how much money is required for us to compensate? The new question should be, according to me, did the system create the conditions for this person to regain the ability to fish in some way? Did he enable that process? It's very important, or at least move them closer to the life they had before the injury. That is critical. This is not a medical question. This is not a moral judgment. It's a governance question. And then we go down this process of how must we have a learning system in place. Most disciplinary systems are going to work like this. You decide so much of fish, you give the fish, you close the fight. And that's it. Everybody's going down the journey to do what they want. But the Neuro Justice reset is what proposing a different logic. The logic is what? You decide, you give them the fish, you enable them to fish parallel. Make sure that they're empowered there. Observe what is going on. Is it helping them get better? Are they learning from the process? We learn from the process and improve further decisions so that it's a part of what we call as precision in personalized medicine. It can be precision in personalized justice at the end of the day. We don't reopen cases. We're only looking forwardly, prospectively to what's happening. And then the AI is there for us to give the last mile connectivity to know what is going on. So this is what happens. So it's not about reducing compensation. I'm not saying at the other end, are you reducing compensation? Not at all. Let us be absolutely clear. It's not about giving fewer fish. It's not about cutting rations. It's not about abandoning people. It is not that. It is we have to sustain life and get them back. A message to the judiciary is, your role was never to count the fish, your role was to do justice, enablement aware. It is our fault as the healthcare professionals. We have not been clear enough to give you that power and that clarity so that you could make those decisions, remove the guesswork, align the judgments with lived reality and prevent lifelong dependency. So it's our role as experts to actively assist you in delivering this process. So message to the insurance was never meant to be an endless fish distributor. It's not an adversary, it's not a silent player. It was a risk balancing institution. Again, it's our responsibility as healthcare experts to actively assist you people to give you the right clarity so that you can make the right calculations that happen. So if you go, I call it risk intelligence. It's not just about going passively at the end of the day. Unless we build this, do this, Viksit Bharat 2047 will not happen. Why does it matter even globally? This is not an India-specific problem. I don't know how many of you read the paper 3 days ago. There was information given in Parliament by the minister that 2024, 1,77,000 Indians died on Indian roads. Just in 1 year, 2024. That is 485 Indians every single day. If this had happened by a terrorist act, we would have called it, we would have declared war on terrorism. Why haven't we declared war on road traffic accidents still? Why are people so indisciplined? That is what we are trying to head. This death, please understand, is those who are on the road died or a few hours after they reach hospital. It is not the people who died 1 week later, 1 month later, 6 months later. We don't have data for that. What about the 5-10 times more people who are disabled? Young people like us, people who are breadwinners of the families, people who are to build the future of this country are either dead or disabled. And that for me is unacceptable. So we have to start from prevention all the way to take them to the other end by asking us a deeper question. How do we operationalize this? WHO is struggling with the same thing at the end of the day. The deeper question is, did the system ever check that the fishing became more responsible? And this importance is for global disability governance. India is a living laboratory for this. We can try because there are so many numbers. We can work on this to make it happen. What is the movement saying? We are not deleting compassion. We are not deleting outdated assumptions. We are deleting outdated assumptions. Sorry. We are not saying that you cannot fish. We are going to provide you the empower to make this happen. And this is akin to how UPI democratized financial transactions. Today, even a beggar has a UPI code. You know, when they come near. So everybody has access to the same technology, same access to the same thing. We have democratized financial inclusion. In the same way, we have democratized rehabilitation, empowerment, and that's the only way possible. We know the other, the GST, fast tag, anything is possible. I think all of us have to make up our mind to make this happen. So the invitation, this is not an attack on the past. Please understand. I'm just saying that what has happened, we have come so far. We have had our learnings. We have seen what has worked, what has not worked. The important thing is this invitation of the future, which is unconstrained by the past. We don't have to look at the past. It's not like a green shirt or a yellow shirt. It is from the pupa to the butterfly. It's a transformational thought process that's happening. The invitation to the judges, the insurers, the lawyers, the policymakers, clinicians, global institutions. Let us reboot, let's not resist, let us learn. And that's what it is, so that we see it's not complete until their people are empowered. The final note is, this presentation is not meant to start conversations, not to end them. It's a reset, a reboot button, not a verdict. Thank you very much for patience. So now I will request Justice Arun Kumar, who has graciously agreed to launch our book, Lokarpana book, to come forward to do the book launch. You're going to see a surprise now, what we're going to do.
Thank you, sir. We thank the Honorable Chief Guest for graciously unveiling the Neuro Justice Trilogy and the handbook. With the Lokarpana complete, we now take a moment to acknowledge the minds and commitment behind this body of work. The Neuro Justice Trilogy and handbook are the results of years of interdisciplinary engagement, bringing together neuroscience, rehabilitation, law, ethics, and lived human experiences. They reflect not only academic rigor, but also a deep concern for dignity, function, and justice as experienced in everyday life. It is therefore our privilege to felicitate the authors of this work, Dr. Sharan Srinivasan and Dr. Pratibha Sharan, for their vision, scholarship, and sustained commitment to conceiving and advancing the Neuro Justice movement. May I now request Honorable Chief Guest, Justice Arun Kumar, Honorable Justice R.V. Ravindran sir, to kindly felicitate the authors of Neuro Justice, Dr. Sharan Srinivasan and Dr. Pratibha Sharan. Please, sir. We have just been joined by Shri Dinesh Gundurao, Honorable Minister for Health and Family Welfare, Government of Karnataka. Welcome to this Lokarpana event, sir. May I now request Dr. Sharan Srinivasan, Dr. Pratibha Sharan, authors of the Neuro Justice Trilogy and Handbook, to kindly present a small token of gratitude to Shri Dinesh Gundurao, sir. May I now request Dr. Sharan Srinivasan, Dr. Pratibha Sharan, authors of the Neuro Justice Trilogy and Handbook, to kindly present a small token of gratitude to Shri Dinesh Gundurao, sir. With the Lokarpana complete, we now call upon one of the country's most respected jurists, Honorable Justice R.V. Ravindran, former judge of the Supreme Court of India. Justice Ravindran is widely recognized for shaping India's motor vehicle accident and disability compensation law through landmark judgments, two of which, in particular, have had a transformative impact. Sarla Verma versus Delhi Transport Corporation, 2009, and Raj Kumar versus Ajay Kumar, 2011. Together, these decisions laid down uniform principles for assessing loss of livelihood and functional disability arising from orthopedic and neurological injuries, and clarified how such functional loss must be translated into compensation. Importantly, the structured approach articulated in these judgments also brought certainty to death cases arising out of motor vehicle accidents, ensuring that compensation reflected real functional and economic loss rather than arbitrary estimates. In doing so, Justice Ravindran's jurisprudence linked legal principle directly to human impact, bringing clarity, predictability, and humane fairness to the law. It is this ability to connect legal doctrine with lived reality that makes the next moment especially meaningful. Under a Rebooting the Brain initiative directed toward public education and awareness, we had the privilege of recording a podcast episode featuring Honorable Justice A.V. Chandrasekhar, former judge of the High Court of Karnataka, and one of our guests of honors today, hosted by Dr. Sharan Srinivasan and Dr. Pratibha Sharan. There could be no better person to release this podcast promo than Honorable Justice R.V. Ravindran sir himself. I now request Honorable Justice R.V. Ravindran to kindly release the podcast promo, carrying the spirit of Neuro Justice movement beyond today's gathering and into wider public dialogue. Please, sir.
Persons who are afflicted with neurological disabilities should get justice. Otherwise, it will be a violation of Article 14 of the Constitution.
We are socially being just, and we are empowering the person to get back and come, and that's going to help the country, sir. Because the world cannot afford disability, sir.
Judges also find difficult, especially in the motor accident claims tribunal dealing with cases. They find it difficult because there are no guidelines, As a result of the same, most of the cases are not given priority.
Road traffic accidents, majority of the people are men, and men in the working period, like maybe around 30 years to 50 years of age group. This is the prime time where they are married and they have children probably, and you're wiping off the sindoor of that lady.
ಬೆಳಗ್ಗೆ ಮಧ್ಯಾಹ್ನ ಅವ್ರಿಗೆ ಕೇಸರಿ ಬಾತ್
Kesari bath. He wants kesari bath.
Only, not once, only ಕೇಸರಿ ಬಾತ್.
He doesn't eat anything.
No biryani, nothing. Anything you put, he spits on the face.
Acha.
Sir, ನಮ್ಮ ಕೇಸರಿ ಬಾತ್ ನೋಡಿ ಸಾಕಾಗ್ಬಿಟ್ಟಿದೆ. Please do something. I don't know, I did not know there was a ಕೇಸರಿ ಬಾತ್ center in the bill.
Section 165 of the Evidence Act states that a judge can put any question to any witness at any point of time.
Don't cheat the system. Be honest. If you are honest, all honest people will support you to get what just compensation you want.
Doctors play a very important role. Doctors are called experts in terms of Section 45 of the Evidence Act. Their evidence has a great bearing on the evidence.
Even so, you are talking Viksit Bharat and you are not empowering the disabled. How unfair is that, sir? How can one section of the country become rich, the other section is marginalized and left behind? How is that possible? We are more worried about what happened in the wars, what happened everywhere else, but we are not addressing this war inside. We need to have a war against this road traffic accidents and the disabilities.
One thing is, in majority of the accidents involving vehicles, it is the people belonging to middle class and below middle class are the victims.
We are one of the few organizations in India which is running neuro rehabilitation from an ICU till the communities. Because the earlier you start rehabilitation, the better the patient's outcome probability is. So we go to the extent of taking the patient to a mall and teaching them how to get onto the escalator so that they can get back to their lives.
Especially right-handed person ಇದ್ರೆ ಅವರು ಅನ್ನ ಕಲಸೋದ್ರಿಂದ ಹಿಡಿದು ಬಟನ್ ಹಾಕೊಳ್ಳಕ್ಕೆ, ತಲೆ ಬಾಚಕ್ಕೆ, ಬ್ರಷ್ ಮಾಡಕ್ಕೆ, ಇನ್ನೇನಾದ್ರೂ ಚಿಕ್ಕ ಪುಟ್ಟ ಕೆಲಸಗಳು ಮಾಡೋದಕ್ಕೆ, ಬರೆಯೋದಿಕ್ಕೆ, ಇದಕ್ಕೆಲ್ಲದಕ್ಕೂ ರೀಟ್ರೈನಿಂಗ್ ಮಾಡಬೇಕು. ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಬರಲ್ಲ.
Just because no bills are produced, does it mean to say that he did not spend anything at all? He has spent, but there are some constraints. Preponderance of probabilities in the civil case.
ನಮ್ಮ ಈ ದೇಶದಲ್ಲಂತೂ ಸರ್ ರೂಲ್ಸ್ ಅಂತ ಯಾರಿಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲ. ವಿ ಆರ್ ಎ ವೆರಿ ಫೇಟಲಿಸ್ಟಿಕ್ ಸೊಸೈಟಿ ಸರ್.
Thank you for launching the promo, sir. We now request Honorable Justice R.V. Ravindran, sir, to please address the gathering.
I'll request for Police Commissioner to support.
My apology, because of my age, I have been permitted to speak first. All will be speaking. Honorable Justice Arvind Kumar, Judge, Supreme Court of India. Sri Dinesh Gundurao, Honorable Minister for Health and Family Welfare. Justice A.V. Chandrasekhar, former Judge, Karnataka High Court. Sri Srimant Kumar Singh, Commissioner of Police, Bengaluru. Dr. V.D. Sinha, President-elect, Asian Australian Society of Neurosurgeons. Dr. Manas Panigrahi, President, Neurological Society of India. Sri K.Y. Venkatesh, Paralympian. Dr. Sharan Srinivasan and Pratibha Sharan, the very distinguished authors, distinguished members of medical and legal profession, ladies and gentlemen. It gives me great pleasure to participate in the Lokarpana of the book Neuro Justice Trilogy, authored by Dr. Sharan Srinivasan and Pratibha Sharan, and say a few words about the book. The book is an important milestone in medico-legal jurisprudence enabling application of medical knowledge to legal issues relating to determination of compensation for accident-related disabilities. To understand and appreciate the need for the book and the relevance of the book, it is necessary to know the background relating to motor accidents and the process of determination of compensation to the victims of the accident. Data shows annually 1.5 lakhs, 1,50,000 people die and 5 lakh people are injured in road accidents in India. 11% of the road accidents in the world occur in India, though it has less than 2% of the vehicles in the world. The figures are dismal, shocking, worrying. The magnitude of the problem can be visualized when we recall that more than 1 million motor accident cases are pending in courts and tribunals, and nearly 4.5 motor accident cases are filed every year in Indian courts. Each case of death or personal injury ends up before Motor Accidents Claims Tribunal for award of compensation. Determination of compensation in cases of death have been made simple and straightforward due to evolution of a simple formula based on 3 facts: age of the deceased, income of the deceased, and number of dependents of the deceased. None of these factors involve medical assessment, and courts do not require the assistance of medical experts to assess compensation. Therefore, you will find in Motor Accidents Claim Tribunal, death cases are disposed of reasonably quickly. But when it comes to personal injury cases, particularly personal injury cases involving head injuries, the cases are not reaching the end, they are pending. There are more cases pending because the judge's inability to understand brain injuries and their effect. That is where the book comes in. On the other hand, determination of compensation in accident cases relating to personal injuries is completely different. Factors like age and income do matter, but the crucial factor is medical evidence about the functional disability and loss of earning capacity. Therefore, for a just and proper determination of compensation in personal injury cases, courts and tribunal are wholly dependent upon experts in the field of medicine. Majority of the victims of road accidents are either two-wheeler riders or pedestrians. Most of them suffer head injuries. Head injuries to young riders in the earning age group of 20 to 50 years in road accident is a major public health crisis. Head injuries may involve skull fractures, brain hemorrhage, concussions, and contusions. Their effects include physical and mental disability, poor quality of life, or falling into coma or into a vegetative state. They lead to impairments relating to cognition, behavior, vision, speech, swallowing, as also sensory or motor deficits. In many cases, though the head injuries might have healed, the victim may still have chronic headaches, blurry vision, difficulty in concentration, and cognitive issues like loss of memory, lack of attention, difficulty in problem solving and decision making, deficiencies in ability to learn, understand, and interact, which may not be fully resolved. Expeditious disposal is, of course, the requirement and goal to be achieved generally in all litigation, particularly in death cases. But expeditious disposal or settlement may not render justice to cases involving head injuries, as it is important not to assess the loss damage till the patient reaches the MMI, what is known as the MMI stage. MMI refers to the maximum medical improvement stage when the injured person's condition has stabilized and is not expected to improve significantly with further treatment. But that is the stage when no further major medical or emotional changes are expected. Reaching MMI does not necessarily mean that patient is fully recovered, but means that the condition has reached the best possible position, resulting in stopping of curative treatment, but requiring maintenance care such as pain management, physical therapy, medication, or psychiatric counseling. Determination of compensation before MMI stage may result in inadequate compensation being awarded to the injured, thereby resulting in injustice. Thus, it is absolutely necessary to have evidence of neurosurgeons in all cases involving head injuries. The best result can be achieved when the courts and tribunal understand the basics of nature and effect of brain injuries and the residual effect thereof. And similarly, and at the same time, the best results will be achieved if the neurosurgeons familiarize themselves with the requirements of law relating to determination of compensation. When that happens, there will be proper assessment and a clear opinion as to the functional disability and about the loss of future earning capacity. The unfortunate victims of road accidents who have suffered trauma and undergone pain, treatment procedures, monetary loss, and who are left to bear the residual effects of the injuries can be saved from ruination only if they are given proper compensation. There is need for a concerted effort by the judges and lawyers on the one hand, and doctors and medical functionaries dealing with head injuries to ensure that proper treatment is given, functional disabilities and loss of earning capacity is identified and assessed, and appropriate compensation is given to the victims. Dr. Sharan and Dr. Pratibha are renowned experts in the field. Dr. Sharan is a renowned neurosurgeon known for his expertise in functional neurosurgery. He has pioneered innovative approaches to neuromodulation and rehabilitation and has conducted thousands of brain and spinal surgeries. His dedication to improving the functional independence and quality of life of patients with neurological disorders has persuaded him to be a trainer for judges. Dr. Pratibha is known in the field of neuro-rehabilitation and neuropsychology and has a holistic approach towards patient care and rehabilitation. She has been conducting various workshops on stress management, soft skills training, and lifestyle modification related to neuro-rehabilitation. Both have shared their expertise in authoring their second book, Neuro Justice Trilogy, that will be an indispensable companion and handbook not only for doctors but also to lawyers and judges to ensure that the victims get justice by securing adequate and proper compensation. Together, they are rendering unparalleled service to the victims of accidents, and I wish them success in their endeavors in the service of the nation. The book that is released contains 3 sections or volumes. The first volume explains why the brain must be understood before justice can be delivered, aptly titled Brain in the Dock. The second volume is titled Trauma, Toxins, Thinking and AI, deals with how the nature of the damage or injury, the decisions, and the technology will shape justice. The third volume is titled The Justice of Function and the Function of Justice, explaining how function is understood, assessed, and interpreted while rendering justice. One important thing is the language that is used. The authors have tried to write the book in a manner in which people, the common man, can also follow, not only the doctors and judges. In fact, there is always a complaint about legalese, how lawyers and judges use a language and nobody can understand the judgments. There is also a similar complaint about the medicalese, that is the medical language. Earlier, we used to joke about the prescriptions of doctors. Now it has shifted to reports of the doctors. The reports use such language, of course, which the doctors can follow, but we cannot follow. In fact, whenever I get a report and read it, 2 things happen. I either think that the matter is more serious than what it really is, and therefore my blood pressure goes up. Or sometimes, because I cannot understand, I think it is not very serious, therefore I don't go to the doctor, again my blood pressure goes up. I wish the doctors also use simple language, and maybe that is difficult, but the Dr. Sharan and Pratibha have tried to use language in a manner people can understand. I thank them. The book will go a long way in enabling judges and lawyers to understand the function of the brain, effect of injuries to brain, and how to identify the nature, extent, and the effect of brain injuries, and how to effectively assess the functional disability and future loss of earning capacity of the injured and compensate the victims properly, adequately, and justly. You know, ಶರಣ್ ಅವರು ಬರೀ ಫಿಶ್ ಬಗ್ಗೆನೇ ಮಾತಾಡ್ತಾ ಇದ್ರು. ಐ ಡು ನಾಟ್ ನೋ, ಅವರು ಕೆಲವರಿಗೆ ಕೇಸರಿ ಬಾತ್ ಮೇಲೆ ಭಾಳ ಇದಂದರೆ ಇವರಿಗೆ ಫಿಶ್ ಮೇಲೆ. ಐ ಥಿಂಕ್ ಹಿಯರ್ ದಿ ಪ್ರಾಬ್ಲಮ್ ಈಸ್ ನಾಟ್ ಓನ್ಲಿ ಅಬೌಟ್ ಹೌ ಟು fish, how to catch the fish, and then of course how to eat it. For most of us here, that may not be very useful. Unfortunately, persons who are injured, therefore I suggest that as far as accidents involving personal injuries, physical injuries, where the victim does not die but has head injuries, a two-tier system should be followed. That is because, as it was pointed out, it is all the personal injury cases get piled up because judges do not know what to do with them, how to dispose of them, and they are anxious that they should not do injustice because of their hurry or because of their knowledge, lack of knowledge. This book will certainly help. But if the problem is in personal injury cases, you cannot assess immediately after the accident what is going to be the effect. For that, the plateau should come, that is, the treatment should be over, the result should be known, the MMI stage has to be reached. That may take 1 year, that may take 1.5 years in some cases, it may take 2 years in a case. Therefore, some way should be found where the injured is not kept waiting. If the matter is immediately disposed of, he gets a pittance because nobody knows about the result. But if matter is pending for 2 years, what should happen? He has spent so much for the injuries, for the treatment, and his earning has gone. Therefore, in personal injuries cases, I think Justice, I can appeal to you, give some judgment where some immediate compensation is paid to the personal injury cases so that they can live that life for 1 year, 1.5 years, which is the period of treatment. Then the assessment of compensation can do. Some way has to be found out. If you are very, very quick in injury cases, you are doing injustice. If you are delaying the determination, you are doing injustice. Therefore, a way should be found in personal injury cases, and that's where the neurosurgeons come in. First, pay some fixed amount so that he can survive, he can undergo treatment. Then let there be, when the MMI stage is reached, they have the neurosurgeon to assess the injuries and its effect so that he can get full compensation. This is one suggestion which I thought may be of some use. The problems relating to accident and injuries have to be approached and solved with a multi-pronged approach. The first is to strive for better road infrastructure and strict law enforcement relating to driving discipline and wearing of helmet. We have the commissioner here. We saw the commitment with which he has been taking up matters and how the preparations are being made for the new year. I hope that at least in Bengaluru, let us start in Bengaluru. We know that our roads are bad and the police cannot do much about it, but it can do something about the law enforcement, about driving discipline. ಬರೀ ಕನ್ಸೆಷನ್ ಕೊಟ್ಟು ಫೈನ್ಸ್ ವಸೂಲಿ ಮಾಡೋದು is not good. You should ensure that people follow rules, that is when, accidents will be reduced. The second is to build public awareness and participation by teaching basic first aid and rendering of assistance during the golden hour, that is the critical first hour care, in particular handling and transferring the injured from the accident site to a hospital, controlling bleeding and ensuring breathing, which will prevent permanent disability. I have seen in places where accidents have taken place, the bystanders who do not know anything about the first aid, lifting or handling the injured in such a way, the permanent disability occurs there only before the victim reaches the hospital. The third is the treatment itself, involving orthopedic and neurosurgeons, post-surgical care and psychiatric treatment, counseling and physiotherapy. The fourth is ensuring justice by award of fair and reasonable compensation to the victims through courts and tribunals with the assistance of proper medical assessment. The fifth is to assist the victims to get back into their social, professional, and family life. While lauding the good work of Dr. Sharan and Dr. Pratibha, let us do our bit to reduce accidents, to help accident victims, and make the society a better place. Thank you.
Thank you, sir, for the very informative and engaging speech. We've just been joined by Sri Rudrapal Amani, Honorable Deputy Speaker of the Karnataka Legislative Assembly. May I now request Dr. Sharan Srinivasan and Dr. Pratibha Sharan, authors of the Neuro Justice Trilogy, to kindly present a small token of gratitude. Thank you, sir. Moving on, we are honored to have with us Sri Seemant Kumar Singh, a senior Indian Police Service officer of the 1996 Karnataka cadre, currently serving as the Commissioner of Police, Bengaluru City. He has held key leadership positions across the state, including as Additional Director General of Police with the Bengaluru Metropolitan Task Force. His tenure is marked by a strong emphasis on responsive, citizen-oriented policing, where law, order, and empathy go hand in hand. It is my privilege to now invite Sri Seemant Kumar Singh, Commissioner of Police, Bengaluru, to share a few words with us. Please, sir.
Good morning, everyone. Honorable Justice Sri Arvind Kumar sir, Honorable Justice Retired Sri R.V. Ravindran sir, Honorable Justice A.V. Chandrasekhar sir, Sri Dinesh Gundu Rao, Honorable Minister for Health and Family Welfare, Government of Karnataka, Sri Rudrapal Amani, Deputy Speaker, Karnataka Legislative Assembly, Dr. Manas Panigrahi, President, Neurological Society of India, Dr. V.D. Sinha, former Second Vice President, Federation of Neurological Societies, President-elect of the Asian Society of Neurological Surgeons, Padma Shri Sri K.Y. Venkatesh, Paralympian and Disability Ambassador, PRS Neurosciences, and today's authors, Dr. Sharan Srinivasan and Dr. Pratibha Sharan. Various honorable judges sitting in the audience, other guests, and my dear other invitees. First and foremost, it is my privilege that I am sitting and addressing the gathering here in the august presence of all the honorable judges here. I really take it my privilege and deem it as an opportunity for me to speak in front of such senior dignitaries here. As Justice Ravindran just mentioned, I'll be talking about the preventive action. This book on neurojustice would not have been there had the agencies, including the police, did an excellent job of preventing all the accidents, which is not possible, which is just not possible. But yes, sir, it is our duty of all the agencies, including the police, the transport department, and all the other agencies, to see that accidents, especially the accidents on the roads, as you mentioned, sir, has to be brought down. As we are speaking today, I was just Googling that in the last 24 hours, how many deaths must have taken place in India. It is an average of 1,000 per minute. 1,000 per day, 1,000 per day. And if we just, in the morning newspapers on the TV, you are just seeing, in Karnataka, we lost 12 people. In Tamil Nadu, we lost 9 people, just in the last 24 hours. The question here comes is, why we are so irresponsible about driving. Sir, actually, in my 30 years career, wherever I was posted, especially when we were as District Superintendent of Police, this topic on accidents has been very, very dear to me. Because I don't want to clarify, but I've lost a very, very close person in my family in a road accident at a very young age when I was there. I don't want to specify that. So I was very particular when I was Superintendent of Police in all the districts, whether it was in Bijapura, in Bellary, in Kodagu, in Mangalore, whichever districts I worked as Superintendent of Police, I used to experiment how to control the accidents, especially on the highways. One thing I found out, sir, we day by day we are getting best of the cars, best of the automobiles in the industry. The cars are so modern, so effective, and they just try to see that the cars are, and they want to test the speed, whereas the roads, the road condition, and the driving sense has not improved. Maybe I may be driving properly, but the other person is not such a trained driver. So we need to first be very, very particular about issue of driving licenses and cancellation of driving licenses. So I was very particular if the stipulation is there that yes, the person has been involved in a series of accidents, we used to write for driving cancellation of licenses or try to impound the vehicle. And here we see a very drastic change. Like in the rural areas, we find the type of accidents, we are not concentrating on that, but the number of people dying, like as for example, yesterday in Chitradurga on the highway, we had 12 deaths in one accident. It's a huge number. Whereas when we see urban scenario, because of the traffic congestion, maybe the speed of vehicles is very low, very, very slow. But the deaths are also less. So we need to have a shift. We need to have a paradigm shift where we have to concentrate in the rural areas on the highways. One interesting study has been done. In fact, just a few days back, Honorable Justice Sapre, who is the chairman of the former Supreme Court judge, who is the chairman of the Road Safety Society, he has suggested, and Sir will be again coming back to Bengaluru, he has suggested that why not build huge trauma centers on the national highways. Like for example in Bengaluru city, the best of the hospitals dealing with neuro cases are all in the city center. And by the time we get the patients into the city, because we like to send the patients immediately, but you know the traffic condition is so much, the golden hour is lost. So we need to have trauma centers on all the national highways, and it has to be an entire pan-India paradigm shift where we concentrate on highways, and it is the place where it is most required. So Sir was very particular. He has suggested us. He held a meeting with the Chief Secretary, the DG, myself, and the Transport Department, and he has come up with great ideas. So we are going to certainly, sir, we are assuring you, next month we will be sitting down and we are going to implement this along with the Honorable Health Minister trying to identify under CSR schemes of big multinational companies to earmark trauma centers in various on the national highways. This will certainly reduce the number of deaths. Accidents cannot be reduced by this way, but reaching them to the immediate cutting the golden hour. Then very interesting thing which all must be knowing is that whenever someone sees a policeman, they put on the helmet. Especially in the rural areas. Rural areas we don't concentrate. In fact, roads leading to Bengaluru city or any city if you see, whenever the person is coming with his family or driving alone, he puts the helmet on the side. Moment he enters the area where you are under watch of the camera or the policeman, he puts on the helmet. But the danger lies when he or she or wherever the person is on the highway. There the speed is more, the chances of getting hit is more, the chances of accidents are more. So it's a very interesting thing. Just to not be fined, as sir was telling, sir, actually we don't concentrate on that. My motto is, I always tell my traffic people, don't be bothered about traffic fine collection. This fine discount system, what we did was, because sir, what has happened, we have close to 90% of our chalaning system is contactless. So we are contacting, without contact, we are sending them challans and no one is coming to pay the fine. So we are on and off giving this scheme so that we get fines. So basically, we have to understand as a common citizen, as an aware citizen that yes, policeman standing will not save you. You have to be saved by that helmet. That helmet is for your safety. This thing has to go down, and we are trying to do a lot of awareness campaigns on that. It involves awareness and dealing with situations where actually problems have happened, and we are making statistics, we are collecting data where most of the accidents are just on the outskirts of the city, and they are fatal, especially involving two-wheelers. In the city, sir, we find people just to evade or for the sake of helmet, they just put on helmets which are not at all as per the guidelines. Not at all as per, they don't, yes sir, they don't put the strap also. So just to put on the helmet, seeing a traffic policeman. These are things which has to be avoided, and as a responsible citizen, we need to look into those. One more very interesting thing is, sir, as you told, we are preparing for the new year, not only in the coming this thing, especially in Bengaluru city, which is such a developed IT hub. Everyone looks up to Bengaluru city as the most happening city here. We find all the educated, well-aware people, they have this habit of partying later. Partying is not a problem. We don't have any problem with party. But you please take a chauffeur, please take a driver. They themselves, sir, you must have seen every day, last 24 hours in this last week, we are doing an extensive drive for drunken driving. Day before, the figure was around close to 350. Yesterday, this night, it has crossed 500. So 500 people are caught drunken driving. And they're all, most of them are four-wheelers. Four-wheel means you're carrying 4-5 people with you. You are endangering everyone's life. So we just can't understand why these things are happening. So we are going to, in fact, write for license cancellation also. But this is a thing which you are drinking, and most of the cases what happens, like as the normal pedestrian who is going, or a two-wheeler person who is going, is hit by a speeding car. And for no fault of that person, he or she gets into this situation of a trauma where neuro problems and all these problems happen. So my only take on this is, it's a very noble work which Dr. Srinivas and Madam have done, Pratibha Madam have done. And this book will certainly help that in future for both the legal experts, the honorable judges, to deliver justice in the best way so that they get best compensation. Because neuro problem is such, one is something which is genetic or something which is there already in the human body, that is a different issue, but something which we, for our own, because of the problem, fault of someone else, or because of our own mistakes, we get into this. But life has to go on, and we need not be bogged down by such issues. This is a very, very positive positive step forward, very positive step forward. It's a very noble thought, and I really appreciate that all the senior judges, everyone has come. Although today is a holiday, all of us have got down because of such an important issue, and such senior honorable judges sitting with us here for this noble cause. This message should go down. Message, that podcast and everything, this has to go down. We'll also put it in our, we have a very active social media platform. We'll put it in our police, because this helps, it spreads awareness. And as a legal, as the medico practitioners, they are doing a human job while bringing persons affected by such disabilities to normal life. They are always struggling day in and day out. We keep hearing so many good things being done by our doctors, especially our Dr. Srinivas, who has been in the forefront. His concept of taking people to the malls and making them go on these escalators is like, yes, you need to be on the job. You need not have and feel negative what has happened. Something has happened, we have to move ahead. This is the concept that he has taught. I once again appeal to everyone to be safe on the road, to lesser trouble the police, and it is a give and take system. We are not there to trouble anyone. It is only that we want you safe on the road. In fact, I was unfortunately the city police commissioner of Bengaluru city when the unfortunate incident of the plane crash happened, Air India crash happened. I was commissioner there, and I saw it in front of eyes, like, because we got a message of the air crash very fast. The control room, I don't know how, somehow the response was very fast by the police. And it was such a pathetic sight that when the police team reached, in fact, we all reached there, sir, the plane was in one full body was there. And within half an hour, it blew into 3 parts in our presence. And we were seeing people sitting in the seat and dying. Means they were not burnt also. They were due to asphyxia and smoke inhalation. So things are like, and then we were faced with a very technical this thing, whether to treat it as a road accident or means in the legal framework. So these things are always there in legal fraternity, and because the compensation was so high, because the flight was coming from it was an international flight. So the Air India legal top people they had hired legal top people, the insurance people were there, and we were also caught in this thing, whether it is a road accident or it is because the plane has just rolled down the valley. So these things are too unfortunate, but it gives us it's an eye-opener for us how to improve system, how to improve the legal setup, how to improve the medical setup. With these few words, I again thank everyone for having called me here. Wish you everyone a Merry Christmas and a Happy New Year. Thank you.
Thank you, sir, for throwing light on the practical problems and spreading the very important message. We are honored to have with us Shri Dinesh Gundurao, Honorable Minister for Health and Family Welfare, Government of Karnataka, and President of today's occasion. A senior political leader with a strong administrative background, Shri Dinesh Gundurao has played a significant role in strengthening public healthcare delivery, medical education, and welfare-oriented healthcare policies in the state. Known for his people-centered approach to governance, he has supported initiatives that integrate medical science, technology, and ethical decision-making, recognizing that health policy must respond not only to infrastructure and numbers, but also to lived human realities. I now invite Shri Dinesh Gundurao, sir, Honorable Minister for Health and Family Welfare, Government of Karnataka, and President of the event to address the gathering. Please, sir.
Neuro Justice ಇದರ ಲೋಕಾರ್ಪಣೆಯ ಸಮಾರಂಭದ ಸಂದರ್ಭದಲ್ಲಿ ಇದಕ್ಕೆ ಲೋಕಾರ್ಪಣೆ ಮಾಡಲಿಕ್ಕೆ ಆಗಮಿಸಿರುವ ಆನರಬಲ್ ಶ್ರೀ
ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ಕುಮಾರ್ ಅವರೇ ಹಾಗೂ ಮತ್ತೊಬ್ಬರು ಆನರಬಲ್ ಶ್ರೀ ಜಸ್ಟಿಸ್ ಆರ್ ವಿ ರವೀಂದ್ರನ್ ಅವರೇ ಹಾಗೂ ವೇದಿಕೆ ಮೇಲೆ ಆಸೀನರಾಗಿರುವಂಥ ನಮ್ಮ ಆತ್ಮೀಯರು ಹಾಗೂ ಉಪಾಧ್ಯಕ್ಷರು ನಮ್ಮ ಕರ್ನಾಟಕ ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಸೆಂಬ್ಲಿ ಸನ್ಮಾನ್ಯ ರುದ್ರಪ್ಪ ಲಮಾಣಿಯವರೇ, ಹೈಕೋರ್ಟಿನ ಫಾರ್ಮರ್ ಜಸ್ಟಿಸ್ ಆದಂಥ ಆನರಬಲ್ ಎ ವಿ ಚಂದ್ರಶೇಖರ್ ಅವರೇ ಹಾಗೂ ವೇದಿಕೆ ಮೇಲೆ ಉಪಸ್ಥಿತರಿರುವ ಡಾಕ್ಟರ್ ಮಾನಸ್ ಪನಿಗ್ರಾಹಿ ಅವರೇ, ಡಾಕ್ಟರ್ ವಿ ಡಿ ಸಿನ್ಹಾ ಅವರೇ, ಪದ್ಮಶ್ರೀ ವೆಂಕಟೇಶ್ ಅವರೇ ಹಾಗೂ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮದ ರೂವಾರಿಗಳಂತಲೇ ಹೇಳ್ಬೋದು, ದಿ ಆಥರ್ಸ್ ಆಫ್ ದ ಬುಕ್ ನ್ಯೂರೋ ಜಸ್ಟಿಸ್, Dr. Sharan Srinivasan and Dr. Pratibha Sharan avare, and all the other invitees who have come here to participate in this event and to listen to the words of from the August members who are sitting on the dais. So ivattu bala santosh agtade. I'm very happy to be here because this is a subject, I think, which not many people will be really following as such. The concept of neuro justice, or justice for people who are accident victims, and the problems that they face in getting their compensation from the legal framework that we have. And I think anybody who goes through that process, I think they will probably understand it far better, the difficulties in getting true justice and the right amount of compensation. ಅದರಿಂದ ಇದು ಭಾಳ ಒಂದು ಮುಖ್ಯವಾದಂಥ ಸಬ್ಜೆಕ್ಟ್. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ಭಾಳ ಮಾನವೀಯತೆ ಇರುವಂಥ ಒಂದು ವಿಷಯ ಇದು. ಆ ಕುಟುಂಬಗಳಿಗೆ ಯಾರು ಇದರಲ್ಲಿ ಅಪಘಾತ ಒಳಗಾಗ್ತಾರೆ, ಒಂದು ಕಡೆ ಅವರ ಜೀವನದಲ್ಲಿ ಆಗಿರುವಂಥ ದೊಡ್ಡ ಒಂದು ಆಘಾತ ಸಮಸ್ಯೆ, ಎರಡನೇದು ಪರಿಹಾರ ಏನು ಸಿಗಬೇಕಾಗಿರುವಂಥದ್ದು ಅದು ಸಿಗುವಂಥದ್ದಕ್ಕೆ ಅವ್ರೇನು ಹರಸಾಹಸ ಪಡಬೇಕಾಗ್ತದೆ, ಅದರಿಂದ ಅದು ಎರಡನೇ ಒಂಥರ ಡಬಲ್ ವ್ಯಾಮಿ ಅಂತ ಹೇಳ್ಬೋದು, ಆ ಥರ ಆಗುವಂಥದ್ದು. ಸೊ ಈ ಥರ ಇಟ್ ಈಸ್ ಅ ವೆರಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಸಿಚುವೇಶನ್. ಆ್ಯಂಡ್ ಫಾರ್ ಫ್ಯಾಮಿಲೀಸ್ ವಿಚ್ ಆರ್ ಇನ್ ಮಿಡಲ್ ಕ್ಲಾಸ್, ಲೋವರ್ ಮಿಡಲ್ ಕ್ಲಾಸ್ ಆ್ಯಂಡ್ ಪೋರ್ ಫ್ಯಾಮಿಲೀಸ್, I think they get into a situation, either they give up or they even forget about, pursuing the case. And, many of them may not even make even the claims also properly. Because to understand the whole process, you require some amount of, knowledge and education and awareness and the capability and ability to fight it out. So many of them will get into a lot of suffering because of that. And now I was reading somewhere that the people who claim, many accident victims, even to make claims, hardly, it's a very minor percentage of people who actually get into taking claims. Otherwise, they just tend to move on with their lives. There was an article written about a couple of years back when I was just checking on the net now. So they said almost this RTA application was made, and in the year 2023-24, I think, and they said almost 80,000 crores worth of compensation payments are pending. Claims are pending, and almost 10 lakh cases are pending. So that shows one is the volume, and the second thing is the redressal issue of getting the compensation in time. So I think every year this number will only keep increasing. 2 ವರ್ಷದಿಂದ 10 ಲಕ್ಷ ಆಗಿದ್ರೆ ಈಗ ಬಹುಶಃ 11 ಲಕ್ಷ ಆಗಿರ್ಬೋದು. So these are the issues that people are facing. And I think ಡಾಕ್ಟರ್ ಶರಣ್ ಶ್ರೀನಿವಾಸನ್ ಅವರು ಮತ್ತು ಪ್ರತಿಭಾ ಶರಣ್ ಅವರು ಅವ್ರ ಉದ್ದೇಶ ಏನಂತ ಹೇಳಿದ್ರೆ, ಹೌ ಡು ವಿ solve this problem, and how do we help the legal justice system to be able to come out with quicker judgments, so that the judges are helped in understanding this problem. And already ನಮ್ಮ ರವೀಂದ್ರನ್ ಜಸ್ಟಿಸ್ ಅವರು ಭಾಳ ಚೆನ್ನಾಗಿ is already spoken. And these are practical problems. See, there are obviously, we look at the ideal way of doing things. But once we start implementing any law, ನಾವು ಈಗ ನಮ್ಮ ಕಮಿಷನರ್ ಹೇಳ್ತಾ ಇದ್ರು ಹೆಲ್ಮೆಟ್ ಹಾಕೋಬೇಕು ಅಂತ ಇದೆ, ಕಂಪಲ್ಸರಿ ಇದೆ, ಅದು ಹಾಕೊಳ್ತಾ ಇಲ್ಲ. ಇಟ್ಸ್ ಎ ವೆರಿ ಸಿಂಪಲ್ ಥಿಂಗ್. enforce the law, make everyone wear helmets. Very simple. But why are we not able to do it? ಯಾಕೆ ಮಾಡೋಕ್ಕಾಗ್ತಾ ಇಲ್ಲ? Because of there's so many hurdles in the way. Now, when we try to implement a law, the police has to get involved, then the people, for some time it is there. So, simple things also is not so easy to implement in this country. ನಮ್ಮ ದೇಶದಲ್ಲಿ ಏನೇ ಮಾಡೋಕ್ಕೆ ಹೋದರೂ ಕೂಡ ಎಲ್ಲೋ ಒಂದು ಕಡೆ ನಮಗೆ ನಾವು ಮಾಡಿದ್ದೇ ಸರಿ, ನಮ್ಗೆ ಯಾರು ಕೇಳೋರು ಯಾರು ಅಂತ ಆ ಥರ ದಟ್ ಫೀಲಿಂಗ್ ಆಲ್ಸೋ ಇಸ್ ದೇರ್. ಸೊ simple things, even say seat belt, we all know, even I don't put on a seat belt. I know I have to put my seat belt on, but I don't put it on. Me being a minister, health minister, we give upadesha to everybody. But we don't put it on. Hey, yaak hakobekappa anta. I mean, only highways hodaga ಸ್ವಲ್ಪ ಡ್ರೈವರ್ ಫಾಸ್ಟ್ ಓಡೋಕೆ ಶುರು ಮಾಡಿದ್ರೆ ಹಾಕೊಳ್ಳೋಣ ಅಂತ ದೆನ್ ವಿ ಪುಟ್ ಇಟ್ ಆನ್. ಇಫ್ ಇಸ್ ಡ್ರೈವಿಂಗ್ ಸ್ಲೋಲಿ ದೆನ್ ಸೇ ಏನೂ ಆಗೋದಿಲ್ಲ ಬೇಡಪ್ಪ ಅಂತ. ಸೊ ದಿಸ್ ಇಸ್ ದ ಕೈಂಡ್ ಆಫ್ ಥಿಂಗ್ ದಟ್ ಅವರ್ ಮೆಂಟಾಲಿಟಿ ಇಸ್ ಸಚ್ ಆ್ಯಂಡ್ ದ ವೇ ವಿ ಥಿಂಕ್ ಇಸ್ ಸಚ್. So these are all issues, I think, when it comes, like even courts are flooded with so many issues. So this is another issue. So every issue has got a complication. So how do we make it faster, easier, better? How do we make it more transparent? How do we make it quicker? How do we bring out laws? Laws can be made very easy. We can make tomorrow another law saying that increase the payment or increase the interim payment. But again, all this needs to be, justiciable, I think. And of course, court judgments matter. And I think somewhere these victims, they need redressal. It is definitely a need. So when we say all these problems, doesn't mean that we are wash our hands and say that we can't do anything. That cannot be the way, no. We have to do something. We have to see that how we can, what is the way forward? What is it within the system? What can we do to improve it? So definitely, I think Justice Ravindran Koda, he has highlighted that issue, which is a key issue, because I think now the interim compensation they get is about 25,000 rupees. That's all they get. So that is nothing for a person today. 25,000 is nothing. So how we can increase that under the Act also, and maybe even some judgments if they come, so that some reasonable amount is fixed, maybe 2 lakhs, 3 lakhs or 4 lakhs in interim compensation. Or if there's a death that has happened, at least something, so that later on it can be looked into and see what exactly happened and what is the amount actually quantum that is needed for the right, assessment of the claim. So, ee taradella ide. And nam commissioner, so I'll not take too much time. Commissioner also spoke about how the issues about accidents and all that. So my department comes in when after the accident is taken place. Not before. Namdu accident aadmele, how quick is our response? How quick is the ambulance going and picking up the person? And how effectively is the ambulance bringing the person back to and the care in the ambulance? Because that is a golden hour. Whatever is done in that period, that actually has a huge impact. The earlier you're able to, give some treatment to the person in the ambulance before he reaches the hospital, that also has a huge impact. It can, in fact, save lives and save a lot of, severe impairment. So that is one thing. So we are looking at this in a very serious way, and within our own ambulance system, 108 ambulance system, we are looking at how we can improve this whole thing. So right now we have done a proper study, and we've looked into every aspect. And in fact, in Karnataka now, I think we will be the first state which will be taking over the control of 108 into the hands of the government. The entire command control of the 108 was running in the private agency was running it. Now we are taking over the whole thing, and we are trying to see that not only everything is monitored about where the ambulance is, which is the ambulance which can go fastest, and the persons in the ambulance, they are given the required training, and we are also ensuring that the communication between the ambulance and the hospital should start from the pickup of the accident victim, so that he should be designated to which hospital is going to, and he should start communicating with the doctor there. So we'll be providing each and every ambulance tab which will start communicating with the hospital that, see, I'm bringing the so-and-so patient. If it's serious issues, so that they can talk to the doctor at the hospital and say, okay, what can I do, for any other emergency, procedures that I can do while coming in the ambulance. And hospital also can prepare at knowing the state of the patient or the victim, the hospital itself can prepare in advance that, okay, so-and-so is coming and these are the injuries, so let us give him as soon as he comes sometime. So this is the model we are working on, and we already called for all the process. So by February onwards, we are launching this across Karnataka in our 108 ambulances. So this is a huge responsibility that we've taken onto our shoulders, because normally ಏನಾಗ್ತದೆ ಗೌರ್ಮೆಂಟ್ ವಹಿಸ್ಕೊಂಡ್ರೆ ಇವ್ರು ಸರಿಯಾಗಿ ನಡೆಸಲ್ಲಪ್ಪ ಪ್ರೈವೇಟ್ಗೆ ಕೊಡಬೇಕು ಅಂತ ಹೇಳುವಂಥದ್ದು ಜಾಸ್ತಿ. Governments are inefficient, governments are not good, or they're not capable, and that is a general norm. But here, as an initiative, we have decided that we will try and so show that what we can do. And in fact, I think definitely this will be what we are doing. If we do it well, I think across the country, every state may follow us in taking over the 108. Right now, it's all other agencies like GVK and these kind of companies which are running the ambulance services. So, in fact, Government of India, we are working with what is that? The ones which do the forgetting the name, sir. They prepare the software and everything. So we're working with Government and Government of India also. So they are also very keen, because if they can do it well over, look at this model. Not NIC. There's another one, CDAC. We're working with CDAC. So they are also very keen so that this succeeds for us. So this is what we are trying to do, so that at least victim ge how we can give immediate service, good service, and be able to limit the damage that the victim goes through. So these are all what we can do from our side. And also another thing that we have done is, as soon as an accident victim goes to any hospital in the state, there is a law that now we have to give them 1.5 lakhs. That is treatment. Any hospital, they should not charge the patient for the next for minimum 48 hours. 1.5 lakhs is given to any hospital to treat any patient. Doesn't have to be APL, BPL, yare irbodu. That much is assured from our side. But both Government of India and Government of Karnataka, it's in a shared scheme. But we have also added now another 1 lakh as a top-up, in case if they have to stay for 3 or 4 days. So we are going up to 2.5 lakhs as treatment cost that we will bear for any patient who goes to any hospital in the state. And it's mandated by every hospital to ensure that they treat the person. They should not say that, ದುಡ್ಡಿಲ್ಲ, ಕಾಸು ಕೊಡಿ, ಅದೆಲ್ಲ ಹೇಳೋಂಗಿಲ್ಲ. ಅದರಿಂದ ನಾವು ಇನ್ನೊಂದು ಟಾಪ್-ಅಪ್ ಮಾಡಿದ್ದೀವಿ ಈಗ, just about 4-5 months back, about another 1 lakh. So up to 2.5 lakhs is what we can give now to any person who is an accident victim. So ಈ ಥರದೆಲ್ಲ we are trying to do from our side. And definitely legal redressal is going to be a huge thing. And I think this book will help in that matter. And I'm very happy that such a initiative has been taken by these two doctors. ಭಾಳ ಚೆನ್ನಾಗಿ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತು ನಮ್ಮ ಲಂಬಾಣಿ ಸಾಹೇಬರು ನನಗೆ ಅವ್ರು ಹೇಳಿದ್ರು, ಆದೇಶ ಕೊಟ್ಬಿಟ್ರು ಅವರು, ಸರ್ ನೀವು ಫಂಕ್ಷನಿಗೆ ಬರಲೇಬೇಕು ಅಂತ. ಬಿಕಾಸ್ ಐ ವಾಸ್ ಸೇಯಿಂಗ್ ಐ ವಾಸ್ ಹೆಸಿಟೆಂಟ್. ನಾನು ಯಾವುದೋ ಇನ್ನೊಂದು ಪ್ರೋಗ್ರಾಮ್ ಇತ್ತು, ಕ್ರಿಸ್ಮಸ್ ಹಬ್ಬ, ಒಂದು ದಿವಸ ರಜಾ ಸಿಕ್ಕಿದೆ ಅಂತ ನಾನು ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೆ. ಬಟ್ ಲಂಬಾಣಿಯವರು ಇಲ್ಲ ಸರ್, ಅವರು ನನ್ನ ಜೀವ ಉಳಿಸಿದ್ದಾರೆ, ಅವರು ನೀವು ಬರಲೇಬೇಕು ಅಂತ ನಮ್ಮ ಡೆಪ್ಟಿ ಸ್ಪೀಕರ್ ಹೇಳಿದ್ರು. ಸೊ ಆಫ್ಟರ್ ಹಿಸ್ ಥಿಂಗ್ ಐ ಹ್ಯಾವ್ ಕಮ್ ಆ್ಯಂಡ್ ಐ ಆಮ್ ವೆರಿ ಹ್ಯಾಪಿ ದಟ್ ಐ ಕೇಮ್ ನೌ, ಬಿಕಾಸ್ ಐ ಕುಡ್ ಮೀಟ್ such important personalities and judges and such an august gathering here, and it is an honor for me to be here. So thank you, and I wish your initiative and endeavor all the best. Thank you.
Thank you, sir, for being with us today and sharing your thought-provoking words. We are honored to have with us Padma Shri K.Y. Venkatesh, an internationally acclaimed Paralympian, Disability Ambassador of PRS Neurosciences, and a proud recipient of the Padma Shri, one of India's highest civilian honors. Through sport, he has not only represented India on global platforms, but has also challenged deeply held assumptions about disability and inclusion. His work extends beyond medals and recognitions. It speaks to lived realities, to participation, and to the right to be seen, heard, and valued. I now invite Padma Shri K.Y. Venkatesh to please address the gathering, sir.
Hello? Hello? Hello?
Good afternoon, respected dignitaries on the dais, eminent doctors, learned advocates, distinguished guests, ladies and gentlemen. It gives me immense pleasure to be the brand ambassador of a well-known PRS neuroscience, which is doing a human service. On this auspicious occasion of Neuro Justice, authored by my close friend, well-known neurosurgeon, Dr. Sharan Srinivasan, and his wife, Pratibha Sharan. Sharan Srinivasan has participated in more than 2,000 court hearings related to neurological cases, and this vast experience has culminated in the creation of this remarkable book, Neuro Justice, will serve as an invaluable resource in addressing complex neuro-related legal and medical cases. It will benefit not only the patients, but also doctors, advocates, judges, and the insurance fraternity. On this occasion, I extend my heartiest congratulations to the authors, Dr. Sharan Srinivasan, Dr. Pratibha Sharan, and the entire PRS neuroscience team for their visionary and pioneering work. May Neuro Justice inspire meaningful change and set a new benchmark in the field of neuroscience and neuro-rehabilitation. Thank you. Jai Hind.
Thank you for your kind words, sir. We now turn to the leadership in neurological science, where clinical excellence meets education, research, and innovation for patient care. We are honored to have with us Dr. Manas Panigrahi, the current president of Neurological Society of India, the apex professional body representing neuroscientists and neurosurgeons across the country. Dr. Panigrahi is also a highly experienced neurosurgeon and senior consultant at KIMS Hospital, Hyderabad, with over 2 decades of surgical and academic experience. He trained at NIMHANS, Bengaluru, and through his career has performed extensive and complex procedures from cerebrovascular and skull-based surgeries to epilepsy and deep brain stimulations, while contributing more than 140 publications to national and international journals. It's my privilege to now invite Dr. Manas Panigrahi, President of Neurological Society of India, to address the gathering. Please, sir.
Good morning. I'd like to thank Dr. Sharan for inviting me. I had met Sharan, I think, at NIMHANS when we studied together from 1989 to 94. And so this is my 35 years of NIMHANS experience and association with him. I come as a representative from Neurological Society of India to ensure that how NSI can support this movement. I didn't know, he had just told me that it's just a book release, so I had not come with the prepared knowledge, but after coming here, I realized that I have to speak in front of so many distinguished people, Honorable Justice Arvind Kumar ji, the Honorable Minister Sri Dinesh Gundu Rao ji, he has left now, and Honorable Sri Justice B. Ravindran ji, and Deputy Speaker Sri Lamani ji, the Honorable former Judge Chandrasekhar ji, Professor Sinha, and Sri Simant Singh, Commissioner of Police has left, and Padma Shri Mr. Venkatesh ji. This book, Neuro Justice, when he had sent me the manuscript, I didn't go, but today morning I read through all the book. The whole book is oriented towards justice for the patients. As all of you know that the maximum number of accidents happens to the pedestrians, and this book emphasizes how to prevent accident to the common people, how to sail through the accident, and how to go back to their own job or rehabilitate themselves after the accident. I know that if I'll ask one question. In the last 10 years, which year we had the maximum mortality in India? Which year? I know everybody will tell COVID. You agree? No. During the COVID time, the mortality in India was least because there was no accidents. So it's very important that we prevent accidents, and I hope the commissioner was there, that it's so important to prevent accident by following the laws or following the principles. And it's not the having an insurance is important. As I'm going through one chapter of the book on hit and run case, even if I have an insurance of 2 crores, and if I'm hit and run and I do not know who was the driver, who was the accident, who did the accident, the insurance will not pay for me. If I brought to the hospital, fortunately, her Honorable Minister has told 2.5 lakh will be paid from the government, but in my state, nobody will pay. So who will pay? If I'm lucky, I'm in a public hospital, I get treated, but after treatment, who will pay for my rehabilitation? My insurance will not pay because the rule does not allow that. And this book gives the solutions, what is the solution in other countries, and also has told that what government can do that in our country, that in hit and run case, here like I have everything, I have the insurance, I have an insurance of 5 crores, but I cannot use 5 paisa of that. So it's important. These books will educate the policymakers and the judges also to have an interim relief from our primary insurance company, that they help on humanitarian ground and hit and run case, that they are treated in time. I'm sure all of you have seen Gajni movie. Gajni, it's not a movie, it's a real life story for many of our patients we see. A patient who in Gajni was assaulted, but he had an accident, but he could retrain himself to take revenge. So all our patients who have lost their ability to do the original work can be retrained or rebooted if they have the enough finance, and that can only come either from the government or from an insurance company. And hence, insurance companies should not only take care of the treatment, but also the rehabilitation process. So I was very happy, I'll be happy if Saran was born probably 35 years ago, when if this book was there, it would have helped me as a resident when I go to the court to understand and give evidences. Because when I joined as a first-year resident in neurosurgery, many of the things we did not know. And this book has explained so well, not only for the public, it will be good for medical students also to understand neurosurgery and to be interested in neurosurgery, to take up neurosurgery. I'd like to congratulate both Sharan and Pratibha for taking the initiative. I hope you were born 35 years ago so that I could have taken the advantage of that. Thank you.
Thank you for your kind words, sir. From national leadership in neuroscience, we now move to global perspective, one that connects surgical excellence, education, and ethical responsibility across borders. We are privileged to have with us Dr. V. Sinha, President-elect of the Asian Australian Society of Neurological Surgeons, the former Vice President of World Federation of Neurosurgical Societies, former HOD and Senior Professor, SMS Medical College, and a globally respected neurosurgeon and academic leader. Over several decades, Dr. Sinha has played a vital role in advancing neurosurgical practice and also has a keen interest in neuro-rehabilitation. Equally recognized as a clinician, teacher, and mentor, Dr. Sinha's work reflects a deep commitment to patient-centered care and to nurturing the next generation of neurosurgeons. He has been actively engaged in public health awareness efforts, particularly around road safety, highlighting the neurological and human consequences of preventable injuries, an approach that closely reflects the spirit and values of the Neuro Justice movement. I now invite Dr. V.D. Sinha, President-elect of the Asian Australian Society of Neurological Surgeons, to please address the gathering.
Good morning to everyone. And first, I want to thank Dr. Sharan Srinivasan and Dr. Pratibha for invitation for this prestigious gathering. And our chief guest, Honorable Shri Justice Arvind Kumar, Supreme Court of India, Honorable Shri Justice Dr. Mr. Ravindran, former Judge, Supreme Court of India, our Honorable Minister of Health and Family Welfare, Government of Karnataka, and Shri Dinesh Gundurao, other dignitaries on the dais, Shri Rudrapa, Dr. Mr. Honorable Shri Justice Chandrasekhar, and Dr. S.K. Singh, he has left this place for some work. Dr. Manas Pang, he is very active, dynamic president of our society, and Padam Shri Venkatesh. And my greeting to everyone present here, the dignitaries on the dais and those attending this very special event. It is a milestone in neurotrauma care. I am very happy and honored to be part of this event. Being a part of medical care giver, neurotrauma patient for last 40 years I am working in this field. I have been beyond the injury and treatment. With advance in diagnostic and more sophisticated operative care, there is a significant improvement in both survival and longevity. But the social disability, residue, functional rehabilitation are still distant and very painful. I am very happy that an eminent and experienced neurosurgeon, Dr. Sharan Srinivasan, is addressing this in form of his book launch. And congratulations, Dr. Srinivasan, for this. This is a very big thing for us, for our country. It is definitely not just a other textbook, what we see every day or we read, but is an important documentation to help large number of sufferings we see every day in our developing and undeveloped countries. My association to witnessing the problem of trauma patient has been through the professional exposure. Additionally, I've been working for World Federation Neurological Society for Rehabilitation and Reconstruction Neurotrauma Committee for a long time. Now I'm privileged being a chair of same committees, and I'm president-elect of AASNS, which constitutes 2/3 of the world continent, big continent, and we have a lot of underdeveloping countries suffering from these problems. We have found significant difference in rehabilitation in developing and underdeveloped countries. This rehabilitation in developing countries is yet in infancy. We don't have much to offer to victims of road traffic accidents in our developing countries. There are so many problems. Everybody has explained, so I don't go in detail. It needs proper database, including epidemiology, imaging, treatment, and disability grading. Financial and functional rehabilitation are not a part of this program. Neurojustice is unheard. I'm very happy that we heard today and not addressed till now. And it is included today. This is very important day today for us. In fact, I'm look forward for suggestion from book to be highlighted and incorporated in multidisciplinary group of committees which aim for promotion, reconstruction, restoration, and rehabilitation. It should become an important component of rehabilitation. In our countries and low-income countries, there is so much dependency on compensation received through the legal system. That is extremely important for evidence-based system to work. It is wonderful proposition of AI to assist this matter, but AI to work better, the database is most crucial. That's why very important part of this country or any country to have a database, because without database, even AI doesn't work. It is a basic for AI. So finally, just I want to tell that this can form a model in our state, ultimately to go on the entire country. I would propose it to go beyond the national neurojustice movement to get functional and entire world. Recently, we are going to start a program, Save Life and Disability. And this program, we are going to start in India, and we will pass it to underdeveloping countries. And I will be very happy, Dr. Shan, if we join this program. So this will cover a lot of things, and we will be able to help a lot of the disabled and people who got injustice till now. Thank you very much.
Thank you, sir, for bringing a global perspective to the discourse. We now move on to a voice shaped by experience at the intersection of law, governance, and public service. We are honored to have with us Honorable Justice A.V. Chandrasekhar, former judge of the High Court of Karnataka, whose judicial career has been marked by integrity, clarity, and a deep commitment to justice. Appointed to the High Court in 2013, Justice A.V. Chandrasekhar served with distinction across civil and criminal benches, known for the thoughtful and timely disposition of cases and for upholding the rule of law with humanity. Prior to his elevation to the High Court, he served as a district and sessions judge in multiple jurisdictions, bringing seasoned insight to the administration of justice. Beyond the courtroom, his engagement with public service continues through his association with social and health initiatives, particularly Swasthya Arogya Foundation Trust, an endeavor rooted in advancing healthcare access, well-being, and community welfare. It is also important to acknowledge that the idea of documenting and articulating the Neurojustice was significantly encouraged and shaped by Justice A.V. Chandrasekhar, who recognized the practical relevance and societal value of these ideas. It was this encouragement that prompted the authors to draw upon their long-standing clinical and academic experience, working intensively to collate, structure, and present these concepts in a form that could meaningfully inform both professional and public discourse. It is my privilege to now invite Honorable Justice A.V. Chandrasekhar to speak about Swasthya Arogya Foundation Trust and its work. Please, sir.
Honorable Shri Justice Arvind Kumar, respected judge of the highest court of the land, Honorable Shri Justice R.V. Ravindran, former judge of Supreme Court of India, whom we look up for all our needs and guidance, Shri Lamani, Deputy Speaker of the Karnataka Legislative Assembly, two great doctors, Dr. Sinha and Panigrahi, Mr. Venkatesh, the Para-Olympian and the Ambassador of PR Neurosciences, Dr. Sharan and Pratibha Sharan, esteemed judges of the Honorable High Court of Karnataka, learned advocates, and distinguished invitees. It gives me immense pleasure to be in the midst of great people. We have just heard Honorable Shri Justice Ravindran. Justice Ravindran is a name in the law. His thought-provoking judgments have helped us. As judges, we are the beneficiaries. Whatever judgments his lordship has rendered has been very, very helpful in not only disposing of cases, even resolving issues. Many issues get dissolved. That's the manner in which judgments have been. And the anchor has already made a reference about two great judgments in the field of motor vehicle accident. One is Sarala Verma, certainty regarding multiplier to peptide. Another is Rajkumar versus Jaikumar. That is the basis for today's Neurojustice. Honorable Mr. Justice C.M. Joshi requested Mr. Dr. Sharan, why can't you think of writing a book using this tool provided by Justice Ravindran in his eloquent judgment, Rajkumar versus Jaikumar. And he is a regular, both the couple are regular resource persons in Karnataka Judicial Academy, strengthening the judges of our hands in understanding the complexities of neurological disabilities and the impact thereof. We have been raising, we have heard about the deaths arising out of head injuries. But please think over, a man does not die of head injury, but becomes vegetative. Till death, he will be on the bed. We will give compensation. But when a man dies in a road accident, we will grant loss of consortium to the wife, loss of love and affection to the children. But in a case where a man becomes vegetative because of the head injury or a spinal cord injury, the marital pleasure that a wife has is taken away. It's high time that we
think over that also. And she has to look after her husband needs, poor people who don't have toilets, who has two minor children. Those children are denied the pleasure of having the parental affection. These are all things which need to be looked into. I think Honorable Justice Arvind Kumar, Judge of the High Court of the Supreme Court, will definitely take all this into consideration while fine-tuning certain judgments. His Lordship was the executive chairman of the Karnataka State Legal Services Authority. He was in the forefront of organizing Lok Adalats and especially giving prominence to the motor vehicle accident cases. And as the Chief Justice of Gujarat High Court and also as the patron of the Legal Services Authority, he has done wonderful service. So in all aspects and particularly, and Supreme Court is the highest court. Whom should we look at? And we have judges of his caliber, and I'm very confident that this movement will acquire more and more speed. And friends, we are talking of Article 14 and 21 of the Constitution of India. A person who has ability, soon after the accident can get himself admitted to one of the best hospitals and the disability may be reduced. But for poor people, that's not the case. And it is in this regard, the focus is not only on the compensation, but also on the enablement. And in this regard, the book authored by both the couple, Dr. Sharan and Pratibha, is really wonderful. And I'm very happy that both the doctors who are the heads of the institution have taken this to their heart and they said, this will be global. This is a great moment. And this book helps not only the judges, even the lawyers. And I'm very happy that senior insurance company advocates are also here. They also talk to their, and a good idea is mooted by Justice Ravindran. Please think over. It will not only alleviate the problems of those who are affected with head injuries and other injuries, and it will also ultimately cut down the compensation payable by the insurance companies also. If disability is reduced at an appropriate time and final compensation, and one thing is, in POCSO Act, no doctor, no medical institution can deny admission of a child who is, who has undergone sexual assault. And government will take care, whether it is permanent or interim. That's also how those aspects can be embedded to the Motor Vehicles Act is left to the concern, and I think we are very happy that the medical profession is assisting the legal profession in providing the real justice to the victim. I'm one of the trustees of Swasthya Foundation, which is doing wonderful work. I just give a brief idea of what is Swasthya Arogya Foundation. Is created from a simple and deeply held belief, access to good neurological care. It is the charity wing of PRS Neurosciences, an NGO committed to making neuromodulation. Mr. M.N. Vidyashankar, former Additional Chief Secretary, Government of Karnataka. Dr. T. Rajeshwari, former Director, Accreditation, Rajiv Gandhi Health University. Professor Tuppil Venkatesh, CEO and Director, Foundation for Quality India. Professor Sharan Srinivasan, myself and Dr. Zarir H. Sholapurwala are the trustees. This has been doing, and this is led by Dr. Pratibha Sharan, Managing Trustee, whose work reflects a strong commitment to ethical, inclusive, and humane healthcare. Foundation is privileged to be guided by a team of trustees comprising the above distinguished leaders for public administration. I'm grateful to Justice Arvind Kumar for providing a wonderful, an amazing, an insightful forward to the book. It is said that the preamble of the Constitution is key to the whole Constitution. I think Justice Arvind Kumar has spent a lot of time in reading the manuscript sent by Dr. Sharan and Pratibha, and he has virtually gone deep into that book and authored a wonderful foreword. And if you read the foreword, I think half of the work is done. And I'm grateful to the Dr. Sharan and Pratibha for giving me an opportunity. When I was the director of Judicial Academy, I introduced Dr. Satish Babu, a good neurosurgeon, to assist the judges understand the complexities. And after he left over, I introduced Dr. Sharan and his wife Pratibha to the academy, and they are the great resource persons. They have been doing their wonderful service by sharing their experience with our judges. As a result of the same, now judges are in a better position to understand the complexities of neurological disabilities. And wherever I worked as a principal district judge, I used to go around and give priority to all neurological disability cases, because I had a very good contact with Dr. Raja, who was the head of the department of neurosurgery at Manipal, a great name in neurosurgery. But very few judges have contact with the advocates, doctors, neurosurgeons, and neurologists. Therefore, they find it difficult to understand the complexities. Now, with this book, I think it is a great handbook for all the concerned. Thank you.
Thank you, sir, for that thoughtful address. We are honored to have with us Shri Rudrapal Amani, the Honorable Deputy Speaker of Karnataka Legislative Assembly. With a strong grounding in grassroots public life, Shri Lamani has consistently worked towards inclusive governance and the strengthening of democratic institutions. In his role as Deputy Speaker, he plays a vital part in upholding the dignity of the House, ensuring fair legislative process, and safeguarding constitutional values. Shri Rudrapal Amani's association with this platform is also personal. Following a road traffic accident, he underwent structured neuro-rehabilitation at PRS Neurosciences, and through sustained efforts and rehabilitation was able to return to public life and resume his responsibilities within 6 months, an experience that reflects the possibilities of recovery. I now invite Shri Rudrapal Amani sir to please address the gathering.
ಪುಸ್ತಕ ಬಿಡುಗಡೆ ಸಮಾರಂಭದಲ್ಲಿ ಭಾಗವಹಿಸಿದಂಥ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂಥ ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ಕುಮಾರ್ ಸರ್ ಅವರೇ, ಹಾಗೂ ಈಗಾಗಲೇ ಇದನ್ನು ಪುಸ್ತಕವನ್ನು ಬಿಡುಗಡೆ ಮಾಡಿ ಹೋದಂಥ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಆರೋಗ್ಯ ಮಂತ್ರಿಗಳು, ಆತ್ಮೀಯ ಸ್ನೇಹಿತರಾದಂಥ ದಿನೇಶ್ ಗುಂಡೂರಾವ್ ಅವರೇ, ಈ ಪುಸ್ತಕವನ್ನು ಅರ್ಪಣೆ ಮಾಡಿದಂಥ ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ಸರ್ ಅವರೇ, ಹಾಗೂ ಈ ಪುಸ್ತಕದ ರೂವಾರಿಗಳು, ಇದನ್ನೆಲ್ಲ ಬರೆದು ಪ್ರಸಿದ್ಧಪಡಿಸತಕ್ಕಂಥ ಡಾಕ್ಟರ್ ಶರಣ್ ಮತ್ತು ಡಾಕ್ಟರ್ ಪ್ರತಿಭಾರವರೇ, ಮತ್ತು ವೇದಿಕೆ ಮೇಲಿರುವ ಎಲ್ಲ ಡಾಕ್ಟರ್ಗಳೇ, ಮುಂಭಾಗದಲ್ಲಿರುವ ಎಲ್ಲ ಹಿರಿಯರು, ನಾನು ಆಕಸ್ಮಿಕವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗಗೊಂಡಿದ್ದೆ. ನನಗೆ ಸೆಷನ್ ಮುಗಿಸಿ ಹೋಗುವಾಗ ಒಂದು ಆಕ್ಸಿಡೆಂಟ್ ಆಯಿತು. ಆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ ಡಾಕ್ಟರ್ ಸತೀಶ್ ರುದ್ರಪ್ಪರವರು ನನ್ನ ಆಪ್ರೇಷನ್ ಮಾಡಿದರು. ತದನಂತರ ಡಾಕ್ಟರ್ ಶರಣ್ ಶ್ರೀನಿವಾಸರವರು ತಮ್ಮ ಫಿಸಿಯೋಥೆರಪಿಯಲ್ಲಿ ನನಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ, ಕಾನ್ಷಿಯಸ್ಸೇ ಇರಲಿಲ್ಲ ಆ ಸಂದರ್ಭದಲ್ಲಿ, ನನಗೆ 5-6 ತಿಂಗಳ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟು ನನ್ನನ್ನು ವಾಸಿ ಮಾಡಿದರು. ಮತ್ತು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಅವರು ಪುಸ್ತಕವನ್ನು ಬಿಡುಗಡೆ ಮಾಡ್ತವೆ, ತಾವು ಬರಬೇಕು ಅಂತ ಹೇಳಿದಾಗ, ಈ ಪುಸ್ತಕದಲ್ಲಿ ಒಂದು ಕಡೆ ಜಸ್ಟಿಸು, ಒಂದು ಕಡೆ ಸರ್ಜರಿ ಮಾಡ್ತಕ್ಕಂಥ ಕಥೆ ಇದೆ. ವಿಶೇಷ ಇದು, ಎಲ್ಲಿ ನಾನು ನೋಡಿಲ್ಲ ಇಷ್ಟು ವರ್ಷಗಳ ಕಾಲ. ಎಲ್ಲರಿಗೂ ನ್ಯಾಯ ಸಿಗಬೇಕು, ಮತ್ತು ದವಾಖಾನೆಗೆ ಹೋದಾಗ ನಮಗೆಲ್ಲ ರೀತಿಯಿಂದ ಅವರು ಸಹಾಯವನ್ನು ಮಾಡ್ತಾರೆ. ನಾನು ಭಾಳ ಜನ ಡಾಕ್ಟ್ರುಗಳನ್ನು ನೋಡಿದ್ದೀನಿ ಎಲ್ಲ ಸರ್ವಿಸ್ನಲ್ಲಿ. ಅವರು ಸ್ವತಃ ಗಂಡ ಹೆಂಡತಿ ಇಬ್ಬರೂ ಬಂದು ನಿಂತ್ಕೊಂಡಿದ್ದು ಎಲ್ಲ ಪೇಷಂಟ್ಗಳನ್ನು ಭಾಳ ಆತ್ಮೀಯತೆಯಿಂದ, ಭಾಳ ಸಂತೋಷದಿಂದ ಅವ್ರನ್ನ ಕರೆದು ಮಾತನಾಡಿಸ್ತಾರೆ. ಅಲ್ಲಿ ಬಂದಿರತಕ್ಕಂಥ ಪೇಷಂಟ್ಗಳು ಎಲ್ಲ ಈ ಪಾರ್ಶ್ವವಾಯು ಹೊಡೆದಕ್ಕಂಥ ಪೇಷಂಟ್ಗಳು. ಅವ್ರನ್ನ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಭಾಳ ಖುಷಿಯಿಂದ ಇದನ್ನು ಮಾಡಿಸ್ತಾರೆ. ಜೊತೆಗೆ ನಾನು ಬಂದ ನಂತರ ದಾವಣಗೆರೆಯಲ್ಲಿ ಮತ್ತೊಂದು ಸಂಸ್ಥೆಯನ್ನು ತೆರೆದು ಆ ಭಾಗದ ಜನರಿಗೂ ಅನುಕೂಲ ಆಗಬೇಕು ಅನ್ನೋ ದೃಷ್ಟಿಯಿಂದ ಇವತ್ತು ಅವರು ಒಂದು ಉತ್ತಮ ಕೆಲಸವನ್ನು ಸಮಾಜದಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇವತ್ತು ಅವರು ಬ್ರೈನಿನ ಬಗ್ಗೆ ನ್ಯೂರೋ ಜಸ್ಟಿಸ್ ಪುಸ್ತಕವನ್ನು ಬಿಡುಗಡೆ ಮಾಡೋದ್ರ ಬಗ್ಗೆ ಮತ್ತು ಒಂದು ಬ್ರೈನ್ ಒಂದು ಮಾಡ್ತಕ್ಕಂಥ 2 ಪುಸ್ತಕಗಳನ್ನು ಬರೆದಿದ್ದಾರೆ. ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಮೆಡಿಕಲ್ ಓದ್ತಕ್ಕಂಥ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಈ ಪುಸ್ತಕಗಳು ಟೆಕ್ಸ್ಟ್ ಬುಕ್ ಆಗಿ ಹೊರಹೊಮ್ಮಲಿ, ಆ ದಿಶೆಯಲ್ಲಿ ಅವರ ಪ್ರಯತ್ನ ಇರಲಿ. ದೇವರು ಅವರಿಗೆ ಭಾಳ ಸರ್ವಿಸನ್ನು ನಾನು ನೋಡಿದ್ದೇನೆ. ಭಾಳ ಜನ ಡಾಕ್ಟ್ರುಗಳು ಯಾವುದೇ ರೀತಿಯಿಂದ ಸೋಷಿಯಲ್ ಸರ್ವಿಸ್ ಮಾಡ್ತಕ್ಕಂಥ ಅವಕಾಶ ಸಿಕ್ಕಿದೆ. ಇದು ಎಲ್ಲರಿಗೂ ಸಿಗೋದಿಲ್ಲ. ಅದರಿಂದ ಇವತ್ತು ಈ ವೇದಿಕೆಯಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟಿನ ಜಸ್ಟಿಸ್ಗಳು ಮತ್ತು ನಮ್ಮ ಅನೇಕ ಡಾಕ್ಟ್ರುಗಳು ಬಂದು ಅವರಿಗೆ ಆಶೀರ್ವಾದ ಮಾಡಿದ್ದೀರಿ. ಇದು ನಿರಂತರವಾಗಿ ಸಾಗಲಿ. ಅವ್ರ ಜೀವನದುದ್ದಕ್ಕೂ ಕೂಡ ದೇವರು ಅವರಿಗೆ ಒಳ್ಳೆಯದನ್ನು ಮಾಡಲಿ ಅಂತ ಹಾರೈಸಿ ನನ್ನನ್ನು ಕರೆಸಿ ಮಾತಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಂಥ ಡಾಕ್ಟರ್ ಶರಣ್ರವರಿಗೂ ಡಾಕ್ಟರ್ ಪ್ರತಿಭಾರವರಿಗೂ ವಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೇನೆ. ಜೈ ಹಿಂದ್.
Thank you so much for your kind words, sir. Before we proceed to the most awaited chief guest address, we would like to pause to hear a perspective from within the legal fraternity, one that engages thoughtfully with the questions explored in Neurojustice. We are pleased to present a video message by Senior Advocate Vivek Subbareddy, President of the Advocates Association, Bengaluru, sharing his reflections on Neurojustice and its relevance to contemporary legal discourse. May we now have the video, please?
ನಮಸ್ಕಾರ ಸ್ನೇಹಿತರೆ. ಡಾಕ್ಟರ್ ಶರಣ್ ಅವರು ಬಹಳ ಪ್ರಯಾಸಪಟ್ಟು 4 ವಾಲ್ಯೂಮ್ಗಳಲ್ಲಿ ನ್ಯೂರೋ ಜಸ್ಟಿಸ್ ಎನ್ನುವ ಪುಸ್ತಕವನ್ನು ಕರೆದಿದ್ದಾರೆ. ಈ ಪುಸ್ತಕವನ್ನು ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ಕುಮಾರ್ ಅವರ ಹಸ್ತದಿಂದ ಬಿಡುಗಡೆಯಾಗಲಿದೆ. ಈ ಪುಸ್ತಕ ನಿಜವಾಗಿಯೂ ಸಹ ಸಹಸ್ರಾರು ವ್ಯಕ್ತಿಗಳಿಗೆ ಭವಿಷ್ಯದಲ್ಲಿ ಪರಿಹಾರವನ್ನು ಕಂಡುಕೊಳ್ಳುವಂತಹ ಪುಸ್ತಕ. ನಮ್ಮ ಭಾರತದಲ್ಲಿ ಬ್ರೈನ್ ಇಂಜುರೀಸ್ ಆಗುವಂಥ ಮೆದುಳಿಗೆ ಪೆಟ್ಟಾಗಿ ಬಹಳಷ್ಟು ಯಾತನೆಯನ್ನು ಅನುಭವಿಸುವಂತಹ ಪರಿಸ್ಥಿತಿ ಹೈ ಸ್ಪೀಡಿಂಗ್ ಆಕ್ಸಿಡೆಂಟ್ಸ್ನಲ್ಲಿ ನಾವು ನೋಡ್ತೀವಿ. ಇಂತಹ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಅವರಿಗೆ ಪರಿಹಾರವನ್ನು ಹೇಗೆ ಕೊಡಬೇಕು ಹಾಗೂ ಡಿಸಬಿಲಿಟಿಯನ್ನು ಹೇಗೆ, ಅಂಗವಿಕಲತೆಯನ್ನು ಹೇಗೆ ಮೌಲ್ಯಮಾಪನ ಮಾಡಬೇಕು ಎನ್ನುವ ವಿಷಯದಲ್ಲಿ ಡಾಕ್ಟರ್ ಶರಣ್ ಅವರ ಪುಸ್ತಕ ನಿಜವಾಗಿಯೂ ಭಾರತದಲ್ಲಿಯೇ ಮೊದಲನೇ. ಟಾರ್ಷಿಯಸ್ ಆ್ಯಕ್ಷನ್ ಅಂತ ನಾವು ಏನು ಹೇಳ್ತೀವಿ ಆಕ್ಸಿಡೆಂಟ್ ಕ್ಲೇಮ್ಸ್ನಲ್ಲಿ ಇನ್ ಇಂಡಿಯನ್ ಲಾ, ಇಂತಹ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ಸ್ಗೆ ಸೂಕ್ತವಾದ ಜ್ಞಾನ ಭಂಡಾರವುಳ್ಳಂತಹ ಪುಸ್ತಕ ಬೇಕಿತ್ತು. ಅಥವಾ ಸೂಕ್ತವಾದ ಹೇಗೆ ಇದು ಡಿಸಬಿಲಿಟಿಯನ್ನು ಹೇಗೆ ಮೌಲ್ಯಮಾಪನ ಮಾಡುವಂತಹ ಪುಸ್ತಕ ನಿಜವಾಗಿಯೂ ಸಹ ಭಾರತದ ಕಾನೂನುಗಳಲ್ಲಿ ಬೇಕಿತ್ತು. ಇದನ್ನು ಡಾಕ್ಟರ್ ಶರಣ್ ಅವರು ಬಹಳಷ್ಟು ಸಮಯ ಕೊಟ್ಟು, ಅವರು ಈಸ್ ಅ ಲೀಡಿಂಗ್ ಡಾಕ್ಟರ್ ಇನ್ ನ್ಯೂರೋಸರ್ಜರಿ, ಜೈನ್ ಹಾಸ್ಪಿಟಲ್ನಲ್ಲಿದ್ದಾರೆ. ಹಾಗೂ ಅನೇಕ ಜಪಾನ್ನಲ್ಲಿ ಲೇಟೆಸ್ಟ್ ಮೆಥಡ್ಸ್ ಆಫ್ ಆಪರೇಷನ್ನ ಸರ್ಜರೀಸ್ನ ಕಲ್ತು ಬಂದಂಥವರು ಹಾಗೂ ವಿಶ್ವವಿಖ್ಯಾತಿಯಾಗಿ ಅವರು ಹೊರಹೊಮ್ತಾ ಇದ್ದಾರೆ. ಇಂತಹ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಸುಮಾರು ಸಮಯವನ್ನು ನ್ಯೂರೋ ಜಸ್ಟಿಸ್ ಅನ್ನೋ ಪುಸ್ತಕಕ್ಕೆ ಅವರು ಕೊಡುಗೆಯಾಗಿ ನೀಡಿದ್ದು, ಇದು ಕೋಟ್ಯಾಂತರ ವ್ಯಕ್ತಿಗಳಿಗೆ ಒಳ್ಳೆಯದಾಗುವ ಸಂಭವವಿದೆ. ಭವಿಷ್ಯದಲ್ಲಿ ಈ ಪುಸ್ತಕ ಪ್ರತಿಯೊಬ್ಬ ಲಾಯರ್ ಮನೆಯಲ್ಲೂ ಸಹ ಇಟ್ಕೊಳ್ಳೇಬೇಕಾದ ಮಸ್ಟ್ ರೀಡ್ ಬುಕ್ ಆಗಲಿ ಅಂತ ಆಶಿಸ್ತಾ, ಅವ್ರಿಗೂ ಸಹ ವಂದಿಸುತ್ತಾ ನಾನು ಅವರಿಗೆ ಒಳ್ಳೆಯ ಇಂತಹ ಪುಸ್ತಕವನ್ನು ಮುಂದೆಯೂ ಬರೀಲಿ ಅಂತ ಕೇಳ್ಕೊತೀನಿ. ನಮಸ್ಕಾರ.
We thank Senior Advocate Vivek Subbareddy for sharing his thoughtful reflections with us, despite being unable to join us in person today. We now come to the most awaited address of today's program by Honorable Justice Arvind Kumar, widely respected for his clarity of reasoning, depth of legal scholarship, and steadfast commitment to constitutional values. Over a distinguished judicial career spanning civil, criminal, and constitutional domains, Justice Arvind Kumar has been recognized for balancing efficiency with judicial rigor, ensuring the timely disposal of a large volume of cases without compromising the quality or rigor of legal reasoning, fully conscious of the responsibility that comes with the Supreme Court's constitutional role under Article 141, by which his judgments declare law binding across the country. Before his elevation to the Supreme Court of India, Honorable Justice Arvind Kumar served with distinction as Chief Justice of the Gujarat High Court and as a judge of the High Court of Karnataka. During his tenure in Gujarat, he took up the challenge of case pendency as a priority and introduced administrative measures to improve courts' efficiency. One such initiative was the introduction of justice clocks in courtrooms, which tracked and publicly displayed case pendency and disposal data to enhance transparency and accountability in judicial administration. He also supported innovative programs such as Signal Schools, which brought educational access to children in challenging circumstances, underscoring a practical and compassionate approach to justice. His presence at this Lokarpana lends profound constitutional and ethical significance to the ideas explored in Neuro Justice, which seek to bridge law, science, and lived human experience. I now invite Honorable Justice Arvind Kumar, Judge, Supreme Court of India, and Chief Guest of the event to deliver the Chief Guest's address. Please, sir.
ಎಲ್ರಿಗೂ ಸ್ಪೀಚ್ ಕೇಳಿ 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 ಆಲ್ರೆಡಿ ಬೇಜಾರಾಗಿರಬೇಕು. ಆದರೂ ಒಂದು 10 ನಿಮಿಷದಲ್ಲಿ ನಾನು ಮಾತಾಡೋಣ ಮುಗಿಸ್ತೀನಿ. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. I consider it a privilege to be present in this august audience. Honorable Justice R.V. Ravindran, former Judge of Supreme Court of India, Shri Rudrappa Lamani, Deputy Speaker, Karnataka Legislative Assembly, Justice Chandrasekhar, former Judge of High Court of Karnataka, Mr. Manas Panigrahi, President, Neurological Society of India, Mr. V.D. Sinha, former VP, World Federation of Neurological Societies, Padma Shri Venkatesh, Para-Olympian and Disability Ambassador, Dr. Sharan Srinivasan, author of the Neuro Justice Trilogy, Dr. Pratibha Sharan, co-author, my esteemed brothers, Justice Rachaya and Justice Basuraj, members of the judiciary. I had seen Mr. Bharat Kumar, also the Registrar General of High Court of Karnataka, who is present there. Members of the bar, academicians, students, representatives of civil society. Most importantly, I acknowledge the presence of the doctors, neuroscientists, and medical professionals gathered here today. I consider it as a privilege for 2 reasons to be here. One is, I am in the midst of very learned people. And another additional reason is, today I got the benefit of sharing the dais with Honorable Justice Ravindran, whom I consider as friend, philosopher, and guide. He is an ocean of knowledge. It is his judgments. I have appeared before him. I have seen him as an advocate. I have appeared before him as a judge in Karnataka High Court. And he is an answer to all the problems. He gives answer to every problem. He is having a treasure of knowledge. And to be in his presence, to sit next to him, I consider it as a proud privilege. I begin my expressing my sincere gratitude to the organizers for inviting me to participate in this Lokarpana of the Neuro Justice Trilogy. The choice of venue itself is significant. NIMHANS is not merely an institution of medical excellence. It is a space where science, service, and compassion converge. To speak here on a subject that bridges law and neurosciences is both honor and responsibility. Hindu scriptures describe doctors as Vaidyo Narayana Hari, and this aptly applies to Dr. Sharan and his wife. I would like to place on record my sincere appreciation for the couple whose sustained efforts have culminated in the Neuro Justice Trilogy book. This work reflects not only the academic diligence, but a clear understanding of the needs of justice delivery system. The process of collating clinical experience, engaging in interdisciplinary collaboration, and carefully conceptualizing how neurological science can inform legal decision making is neither simple nor routine. It requires patience, intellectual honesty, and a deep respect for both disciplines. What stands out in this trilogy is the manner in which complex scientific knowledge has been organized with sensitivity to judicial realities without diluting its rigor. The authors have anticipated the questions that the courts grapple with, particularly in matters involving disability, capacity, and behavior, and have sought to offer clarity where ambiguity prevails. Such work has the potential to assist judges not by prescribing answers, but by enriching the quality of the reasoning. In that sense, this trilogy is likely to serve as a valuable aid to informed adjudication, and the authors deserves appreciation for contributing meaningfully to a more nuanced and human justice system. Before I go to my actual text of the speech which I propose to deliver, which is a short speech, I would like to highlight two aspects. One is which system was put into place by Justice Ravindran when he was the Executive Chairman of Legal Service Authority of Karnataka. He requested all the judges every day after the court hours to sit for 1 hour or 1.5 hours to decide the cases in Lok Adalats. So I was also a part of that once upon a time. That is somewhere in 2011 to 2016. For 5 years I did this. So one day, we were sitting and the parties used to come along with their lawyers for the settlement. One person was brought. He was around 38 years. His wife was pushing the wheelchair. Doctors had certified his disability at about 34%. And the demand from that patient was I should get compensation for 100% disability. Because he had suffered a spinal injury, he had become immobile, paraplegia. Insurance company, as it is always, they were tight-fisted. My friend Mr. Krishnaswamy is also sitting here. He knows, because they have to do their job. We do not find fault with them. They were tight-fisted. They were doing a lot of scrutiny. They said, no, when the doctors themselves have certified 34%, you cannot award 100% compensation. So we called them. I asked the insurance advocate to ask the patient's name, the person's name, who is the claimant. He spoke and nobody understood. Because of neurological problem, he was saying something, he wanted to say his name, but he is unable to say. And it was almost 4 years from the date on which he met with an accident. He was a farmer, and his wife, she had come with a small boy. I asked him, what is this? Is he your son? She said, yes, he is my only son. And is he not going to school? She said, no, from 2 years he has stopped going to school because we don't have money to pay fee. I asked the insurance company advocate, now please tell me what should I do. That advocate folded his hand and said, sir, ನೀವು ಏನು ಕೊಡ್ತೀರೋ ಕೊಟ್ಬಿಡಿ, ನನ್ನ ಕನ್ಸೆಂಟ್ ಅಂತ ತಗೋಬೇಡಿ. ಅಲ್ಲಪ್ಪ ಇದು ಲೋಕ ಅದಾಲತ್ತು, ಇದ್ರಲ್ಲಿ ಕನ್ಸೆಂಟಲ್ಲೇ ಮಾಡಬೇಕು ಅಂತ. ಆಯಿತು, ಒಂದು 60% ಅದು ಮಾಡಿ, 34 ಇರೋದನ್ನ 64 ಮಾಡಿಬಿಡಿ. ಆಗೋದಿಲ್ಲ, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡು. ಆಯಿತು, 70% ಮಾಡಿ. ಇವ್ರು ನಾರ್ಮಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿನವರು ಸ್ವಲ್ಪ ಬಾರ್ಗೇನ್ ಮಾಡ್ತಾರೆ. ಸೊ ಅಲ್ಟಿಮೇಟ್ಲಿ ಐ ವಾಸ್ ಏಬಲ್ ಟು ಪರ್ಸುಯೇಟ್ ದೆಮ್ ಟು 90%. So he was able to get some compensation. We said it should be deposited, not only that, it should be deposited within 4 weeks. And that is the time which 4.5 years, which took for him to get just and reasonable compensation. This is the ground reality. This is one side of the coin. The other side of the coin, myself and one Honorable Judge Justice K.L. Manjunath, we were sitting in the bench in Dharwad. We got a claim petition for enhancement of compensation. And we saw from the medical certificate, 1.5 pages certificate, the doctor, thank you. He had given the certificate. And one person stood up when this case was taken up. We asked him, who are you? He said, I am the person. He said, my lawyer is engaged in the other court, I will get him. We said, you are the victim of this accident? He said, yes. What is your problem? He said, I don't have any problem. My lawyer will come. He said he will get me extra compensation. So he was brought. Lawyer came. He said, my lord, we leave it to your lordships. Some enhancement may give. What is that? Some bruises all over the body. It's a road accident. He was traveling in a two-wheeler. Radius fracture. Normally in the road accident, the radius is the one fibula, tibia, or clavicle bone, or radius. The doctor who had certified the disability was 84% disability. We said, how is it possible? We said, all right, my senior partner was very furious. He said, no, we'll get this doctor. So the doctor was supposed to come. We adjourned it by 5 days. He came, and he came with a stick. He said, are you the doctor? He said, yes. Are you practicing? He said, no, I sit with a table and a chair. I give my letterhead to the advocate. He will type it and I sign it. I get so much money. Have you read this? He said, no. He said, my senior partner was so furious. He said, we are going to send you to jail. He said, sir, please, from today itself, I'll stop practicing. I will give up my medical practice. I will send a letter to the Medical Council of India. I may be pardoned. He was 88 years. This is another. When we asked the advocate, how could you have done this? You have already got sufficient compensation. Because of your case, the trial court had to spend so much time, and we in the High Court, 2 judges, we are spending so much time. Why do you want to unnecessarily? Sir, he thought your lordships will give some little enhancement. Bandasht barli anta. This is the attitude. This also has to stop. And as many lawyers say, yes, sir, we'll have to ask for higher compensation. At least you will give reasonable compensation. There are different dimensions in these compensation cases. So it should be always balanced. What should be the compensation? How much? This is one aspect. The Commissioner of Police was mentioning about the awareness. Somehow, in fact, I was longing to mention this in the presence of both the government and the Commissioner of Police. Unfortunately, they had to leave because of some urgent work. I hope and trust what I say now will also go into their ears. Number one, today we see many a times on this motorcycle, this home delivery, they come. Different platforms are there. And I am told, I did not know till recently, till about 1 year, that if you order something, if you don't get it in a particular time, you need not pay the bill. If it comes late, beyond the 20 minutes or 25 minutes. And one day my daughter and son-in-law ordered for something. He came. I was sitting. I did not know that they had ordered. I asked, who are you? My policeman was not there at my entrance. So probably he had gone to change or something or to the washrooms. So I asked him, who are you? He said, sir, your order. And then I said, what's your name? He said, what? Then I asked him repeatedly. Then he said, wait. Then he removed his earphones. I said, what were you doing? He said, sir, I was hearing to music. He said, throughout I'll be hearing the music, including driving. What is that the police are doing? Have they gone to deep sleep? Number one. Number two, before blaming others, let us look at ourselves. Now, I was told about 2.8% of the accidents in India is caused because of use of mobile phones. Many people, I've seen people, two-wheeler, how? And they are so-called educated people. Is it possible? Is this the awareness we are having? As a vigilant citizen, are we not, this is our society, our country, our nation, are we not supposed to discharge our obligation? This is where, under Article 51A, the fundamental duties which creeps in. It says, you say about all your rights, I have got that right, this right, Article 14, Article 16, Article 19, Article 21. Yes, you also, every citizen has a corresponding duty as prescribed under Article 51A. And particularly, I am very much enamored by one subarticle, Article H. Subarticle H, it says, every citizen should strive hard to achieve excellence in all spheres of life. Wherever they work, whatever you do. So put this question to ourselves. From today onwards, I will be contributing it to the society. I will be contributing to the nation. And I will do my best to see that my environment is good. My people are good. Not only myself and my family, but our neighborhood, our entire society. You should take everyone with you. This should be our motto. We will forget this and only speak about rights. This is the second aspect. Third aspect is the government. I was telling many a times, I saw recently, I was going in my private car, in a signal, a person was driving without a helmet. He came. That policeman came and said, sir, and he wanted to take that key. That is not what normally this police constable do. Sir, put your vehicle on this side. Our inspector is there, you will have to pay a fine because you are going without helmet. He was saying this while taking out the key. You know what was the answer he gave? He said, do you know who I am? I am so-and-so's co-brother. He is a politician. I will give the phone, you talk to him. So by the time the signal fell, we left. That's a different issue. And many a times it has happened, or sometimes at least, they call the police people and say, no, he is known to me, don't do anything, don't put fine, don't issue challan, leave him. Are you doing your duty? Now you are curtailing the policeman to preventing him from doing his duty. Is it not wrong? Is the question which we should ask ourselves. So as a citizen, we should discharge our duties, which is enshrined in the Constitution. Then only we can make a healthy society. Third aspect is, I was in Germany last year. I was just sharing this with Honorable Justice Ravindran. I was there alone for 3 days. One day, one of my friend's son who was in Germany, he said, uncle, I will take you today, you will go out. So he brought a taxi, his private vehicle on hire. We went, he took me to one lake. Then he said, "Uncle, do you want to see fast driving?" I said, "Now itself you are going fast, it is about 100 kilometers. No, real fast." I said, "Police will catch you." No, uncle, here there is permitted. That highway is called Autobahn. I said, "How much speed?" He said, "Around 250 kilometers. I said, "What, are you nuts?" He said, No, this is common, you can go. I said, "Okay, let me see that highway at least. Don't go so fast, I am scared." So let us see that. So we went, he went up to 200 kilometer speed. I said, "Stop, this is enough." And not less than about 40 to 50 vehicles overtook our vehicle. I asked him, "At this rate, if you meet with an accident, you will not get even your body. What do you say?" He said, "Uncle, for your information, for last 16 years, there is not even a single accident. Only 16 years back, it happened because there was a fog. Because of that, it happened. Now that also they have overcome." Now, this is the way in which the roads are maintained. Now, just imagine coming from Bengaluru International Airport to Jayanagar, it will take 1.5 hours. If by chance, while going to the airport, you get jammed in the traffic jam, you will miss your flight. This is bound to happen. Many a times it has happened. Why I am saying this is, these are all things which are connected to the accident. It's a chain reaction. She took me out to some small zoo near her city. So my granddaughter was she ate a plantain, ಬಾಳೆಹಣ್ಣು ತಿನ್ಬಿಟ್ಟು ಸಿಪ್ಪೆ ಕೈಲಿ ಇಟ್ಕೊಂಡಿದ್ದೆ. I was telling her, throw it, it will become very wet, throw it. And she said, bin. 2.5 years. I could not understand. I asked my daughter, what is that she is telling? Ask her to throw that. No, she is searching for waste paper bin. Waste bin. I said, who taught her? No, this is taught in the school itself. The civic sense, traffic sense, how to cross the road. Today, vehicles come on the zebra crossing, and if you go and if you look at him, he thinks as though you have committed a sin. The way he or she looks at you. ಹೇಳ್ತಾರೆ, ಮನೇಲಿ ಹೇಳಿ ಬಂದಿಲ್ವಾ, ನಮ್ಮನ್ನೇ ಬೈತಾರೆ, ಮಾಡಿರೋದು ಅವ್ರ ತಪ್ಪು. This mentality has to go. This has to be overcome. And it is often said that the courts deal with the question of law and facts. In reality, courts deal with people. Behind every brief, every medical record, every statutory provision that we read, there is human life that comes before the judicial conscience, seeking understanding as much as adjudication. Over time, judges come to realize that while statutes and precedents provide structure, they do not always provide answers, particularly when human behavior itself becomes difficult to explain through conventional legal categories. Let me begin by placing you before a situation which is neither dramatic nor uncommon. A criminal appeal is listed for hearing. The accused does not dispute the act alleged against him. The prosecution evidence is largely consistent. Yet, the defense places before the court a set of medical records indicating a history of neurological illness. The trial court has considered the plea of insanity and rejected it. The appellate court has affirmed the view of the trial court. On paper, the legal position appears settled. Yet, as the judge reads and records carefully, a deeper question emerges. The question is not merely whether the accused was aware of what he was doing, but whatever awareness and control are always coextensive. That question does not arise from sentiment. It arises from judicial responsibility. I say so because of one recent judgment where we saw a person was in jail for 37 years for the offense of 302 murder. The medical records available before the trial court and the appellate court, because the plea of insanity can be pleaded even after the judgment is delivered. And when we found out, we asked for the status report. This is called psychological evaluation report from the jail authorities. And the report we got was shocking. He was not only suffering from schizophrenia, he is completely mentally imbalanced. He doesn't know. Sometimes even if the food is placed before him, he doesn't eat. At that particular point of time, he had completely lost his balance. And that is how, for a small trivial dispute, he had killed his neighbor. And he had spent 37 years of jail. And that remission policy of the state was also not accepted. They also did not accept, and his plea for remission of the sentence had been rejected. Ultimately, on the basis of this evaluation report, we had to release him from jail. Situations such as these illustrate the point at which law encounters the limits of its own assumptions. Traditional legal doctrine has been built on certain understandings of human cognition, intention, and behavior. Those understandings served the legal system well for decades. However, as scientific knowledge advances, courts are increasingly confronted with cases where those assumptions require closer scrutiny. This is particularly true in matters involving neurological conditions, cognitive impairments, and disorders that do not manifest in obvious or visible ways. The defense of insanity is a useful illustration. Courts have consistently emphasized that law is concerned with legal insanity and not medical insanity. This distinction is doctrinally sound and must be preserved. At the same time, it is important to recognize that neuroscience has substantially expanded our understanding of how the brain functions, how decisions are made, and how behavior is regulated. We now know that cognitive awareness, impulse control, emotional regulation, and behavioral inhibitions are distinct neurological functions. A person may possess the cognitive ability to understand and act, yet suffer from an impairment that affects the ability to conduct in a meaningful way. As I said in the beginning, he was only medically certified clinically after evaluation of clinical and radiological evaluation, 34% whole body disability. But he is not even able to hold a glass of water. Completely paralyzed throughout his life. Even to go to the washroom, he has to take the assistance of two persons. A person, the purpose of this is to understand and act, yet which suffer from an impairment that affects the ability to control it in a meaningful way. The law cannot ignore this reality. Doing so does not strengthen justice, it weakens it. This does not mean that courts should abandon established legal standards or dilute criminal responsibility. What it does mean is that courts must apply those standards with a deeper appreciation of scientific context. The purpose of the criminal law is not merely to punish, but to punish justly. Justice requires accuracy. Accuracy requires understanding. Courts routinely deal with issues relating to capacity to contract, consent, capacity to make medical decisions, and capacity to stand trial. Traditionally, capacity has been treated as a binary concept. Either a person has capacity or does not. Contemporary neuroscience suggests that such an approach may be oversimplistic. Disability jurisprudence presents another area where courts increasingly confront neurological complexity. Statutory frameworks often require the assessment of disability in terms of percentage and prescribed categories. While such frameworks are necessary for administrative clarity, they may not always capture functional reality. In service law, courts increasingly encounter cases involving cognitive impairments. learning disorders, post-traumatic neurological conditions, and neurodivergence. These conditions may not justify exclusion from employment, but they may require accommodation. We have that what is known as PWD Act, Persons with Disabilities Act. A person will be perfect. He is a driver. We'll take a case of a driver. He will be driving the vehicle. He meets with an accident. He is unable. His both legs are amputated. Can he be thrown out of employment? The answer is simple. Answer is no, by virtue of Section 48 of the PWD Act. The employer has to provide an alternate employment in the same organization. For example, he may be given as a peon or an attender, or if he knows something about little technology, if he is little more educated, some data entry operator, some alternate arrangements. The legal question in such cases is not simply whether an individual meets a standard, but whether the standard itself can be applied in a manner consistent with dignity and fairness. A constitutional democracy must recognize that human ability exists on a spectrum, that equal opportunity often requires differential treatment. The realm of compensation and tort law, neurological injury presents some of the most challenging questions to the courts. Unlike physical injuries that are medically immediately visible, neurological injuries may have delayed or progressive effects. As Justice Ravindran puts it, if a person who is suffering from neurological imbalances, if it takes 4 years for the case to decide, are the courts be expected to keep silent in not awarding any interim compensation? The answer is no. It can't be a silent spectator. So we will have to do some proactive acts which come to the rescue of that person. Courts assessing compensation must therefore look beyond immediate loss and consider long-term functional consequences. Similarly, in sentencing, neurological conditions may bear upon culpability, rehabilitation, and proportionality. Punishment without understanding risks becomes mechanical rather than judicious. Underlying all these issues is a broader ethical responsibility. Judges are entrusted with significant power. With that power comes the duty to decide the matter with care, humility, and openness to learn more. The Constitution does not expect judges to be expert in every field. It does, however, expect judges to recognize when expertise beyond the law is necessary to avoid injustice. Many a times, you may not be aware, top doctors of the country or top doctors of the city, they don't come to courts to give evidence. They say, no, we will not come. I will send my assistant. He is the file keeper. He will send. He is not the doctor who is treated. And the insurance company will put one question. Doctor, did you treat this patient? He say, no. They will say, cross-examination is over. And they say, this doctor is incompetent to say anything on this medical records. It is only hearsay. It is someone else who has treated, who has certified it. And that man has not come to court because he will not be able to withstand the cross-examination. This technical objection will be taken. Judicial education initiatives undertaken by institutions such as the Judicial Academy and the sustained guidance from jurists like Mr. Justice A.V. Chandrasekhar, who have contributed significantly to building interdisciplinary awareness within the judiciary, is also the need of the hour. Many times, the judges will not be knowing the technicalities about the medical science. So you should have an interaction between the judges and the doctors. Once an advocate was arguing a case before us in the Supreme Court. It is for a small enhancement. All right, I said we'll dispose of this case today itself. I asked that young advocate, you are saying injury, which part of the body was injured? He said, clavicle bone. I said, where is clavicle bone? He said, my lord, clavicle bone? Here, my lord. Mr. Counsel, there is heart, not clavicle bone. Please, do you have your iPad? Take it, remove it. If you have got internet, open it, please see the human skeleton. Where is clavicle bone? Clavicle bone is on the shoulders. And doctors more often say clavicle bone is an ornamental bone. Even if it is fractured, nothing will happen. So the compensation in such cases will be little less. So this aspect, I am not saying that the lawyer he was a young lawyer, he did not know. The lawyers also should learn, and the judges also should know. Suddenly one district judge who is doing on a criminal side, he is posted as a member of the Motor Vehicle Accident Claims Tribunal. He will be concerned only with rape, murder, assault. Now suddenly he says injury. Some judges, they are very well aware. Some judges, they don't know. So learning is every day. A lawyer or a judge, if he says, or even a doctor, I would say, if he says, I know everything in subject what I have learned, that would be the last day in his profession. Our profession is everyday learning process. Even today, I learned something from some quarters. So it is always good for the healthy society that there should be learning process both from the judges. The doctors can come to the judicial academy where they can have some things to know as to how the system works. That would be beneficial to them, to the institution, to the society, and to the patients whom they treat. Because doctors and lawyers approach human problem with different perspectives. Doctors seek to understand, diagnose, and heal. Lawyers seek to classify, argue, and adjudicate. Neuroscience, neurojustice requires these perspectives to converge. Doctors can assist courts by explaining not only diagnosis, but functional implications in clear and accessible terms. I would here like to, before I conclude, I would like to share my own experience. Once we were conducting a civil case in a trial court as a lawyer, and we had taken up a plea that our client was mentally not sound. We had filed an application. The other side contested. So we had to bring a doctor from NIMHANS. The other side cross-examined. The judge was also not able to comprehend the situation. Since I had some knowledge about psychology, because that was my two reasons. One is it was my favorite subject. Two, I had studied this throughout my education, psychology as the main optional subject. So there, we asked the doctor one simple question. Doctor, you have said the IQ is so-and-so, 38 or something, if I faintly remember. Less than 50, he is considered as a person of imbalanced mind, not able to defend himself. So you have certified it as 38. How did you certify? He was trying to give some answers, that, this and all. I think, doctor, if I am wrong, you please correct me. The formula is MA divided by CA multiplied by 100. That is mental age divided by chronological age into quotient is 100. So how do you arrive at the chronological age? That is your physical age from date of birth till today. If it is 49, 50 or 61. MA is mental age. How do you calculate this mental age? They give a test of 25 questions or 20 questions. You will have to answer simple questions. A circle is dash. They will say round, square, rectangle. You will have to tick that whichever is there. On that basis, they decide the minimum IQ of a person. So I think, did you apply this formula? He said, yes. Have you brought the case sheet of that patient? He said, I was here, nobody asked me. The doctor said, you never asked me, judge never asked. I have brought it here, everything is here, please take it. So the judge took that and saw, and he was also convinced that person was mentally incapable of defending himself, so his brother was defending him as a guardian. So that objection which was raised, that the person was unable to defend himself, was brushed aside, and our contention was accepted. Why I say this is, every person who is associated with the institution must learn. And this effort has been made by the doctor couple in their book. Since they wanted me to write a foreword, I said, you are giving me a punishment. The best way to punish the judge is to give him a book and read, because regularly we read. To read additional books is very difficult, because we wind up our day every day at about 12:30, 1 o'clock. Not only me, all the judges in the Supreme Court. Every day they close their office by 1:30. Some judges, it may go up to 2 o'clock also. This is how, otherwise we'll not be able to handle the court next day. We'll be having about 60 to 65 files. In addition to that, Dr. Sharan gave us a simple imprisonment for 7 days. So, and I must say that simple imprisonment was an imprisonment with pleasure, because I learned something. And the credit should go to them. And this language that they have used, as rightly put it by Honorable Justice Ravindran, it is in a simple language where even a common man who does not know either medical jurisprudence or law will be able to understand and comprehend. Lawyers can assist by framing precise questions and address the legal relevance. Judges can ensure that scientific evidence is integrated thoughtfully into legal reasoning. This collaboration strengthens justice. In conclusion, I would say the Neuro Justice Trilogy represents a sustained effort to bridge law and neuroscience. It does not seek to replace legal reasoning with science, but to enrich it. It reminds us that justice is not merely about resolving disputes, but about understanding the human conditions in all its complexity. As we have released this book today, we must continue to reflect on whether our legal doctrines, institutional practices, and educational frameworks are keeping pace with knowledge. Justice is not static. It evolves as our understanding evolves. Ultimately, a just legal system is one that listens carefully, learns continuously, and decides wisely. Since I was associated with this computer committee from long number of years, even in Karnataka, Gujarat, and now also in Supreme Court, in one of the committees, I have been nominated by the Honorable Chief Justice on this virtual courts, how to make it more effective. These matters, particularly the road traffic accident cases. Ladies and gentlemen, you must know that there are about 8 lakh cases across the country where I have collected the information from National Judicial Data Grid, where the compensation which is sought is less than 5 lakhs. Less than 5 lakhs. Injury, fracture, sometimes small bruises, hospitalization. They ask for 1 lakh, 2 lakhs, 3 lakhs. This is taken 2 years, 3 years. Some courts it may take 4 years also. Do you require productive time to be spent for this? I don't say unproductive one, which can be reduced. My simple answer is no. Because why I am saying is I have made some small study and I have submitted a report also, where some advanced countries, part of America, I am not saying entire America, part of America, Brazil, and part of Australia, they have utilized this artificial intelligence to some extent. As rightly put it, case of death, you don't require any medical expertise. He dead is gone. You know his income, you know his dependents. It's only a question of formula. If you make that machine to learn and feed it through the artificial intelligence, I think 1 year we can reduce at least 2 lakh cases per year out of the system. See, once you get into the system, it will be from tribunal, it will come to the High Court, from High Court to Supreme Court, 3 tier. So does it require this? And if you eliminate it at the stage of the preliminary stage itself, these 2 lakh cases can go. Another aspect, in these motor vehicle accident, I have been telling the insurance companies, they have been hearing, smiling, and keeping quiet. This, every system, Customs Act, Central Excise Act, Income Tax Act, direct and indirect taxes, they are what is known as Kar Vivad Samadhan scheme, or Vivad Se Samad. Different types of schemes. If you are into litigation, all right, if you agree, 50% I am going to pay, we will withdraw all the cases, closed. because this system gets locked, the revenue gets locked in that fashion. The question I ask is, cannot the insurance companies, all this you are asking for 2 lakhs, we are going to decide it for on the basis of this. Don't be conservative, be practical and be honest. You are eligible for 1.85 lakhs, not 2.5 lakhs. We will pay it to you within 2 weeks, with interest 6% or 8%, whatever it is. And the claimant, in many cases, we know that where the matter is settled out of court, that is called Lok Adalat, they will forego interest for 2 years. Somewhat give and take, close it, and the system gets unclogged. If this scheme is adopted, one single day, we can dispose of 4.5 lakh cases in the entire country. Only thing is, you will have to have the will. ಇಚ್ಛಾ ಶಕ್ತಿ ಇದ್ದರೆ ಮಾಡ್ಬೋದು. ಅದು ಯಾವಾಗ ಬರುತ್ತೆ ಅಂತ ಆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿನವ್ರುಗಳು ಹೇಳಬೇಕು, ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು. ಸೊ ಇಟ್ಸ್ ಓನ್ಲಿ ಅನ್ ಅಪೀಲ್ ಸೊ ದಟ್ important cases, as Justice Ravindran had said, where it is a case of neurological head injury, the judges will be unable to decide because there will be lack of evidence, lack of understanding, lack of medical evidence. Sometimes there will be no evidence let in at all. You can't find fault with. And because of that, the burden is more on the judges, because the law mandates that we should give just and reasonable compensation. For me to give just and reasonable compensation, I have to have the basis. I have to have the evidence available on record. Until and unless this is available, I will not be able to do this. So we'll have to goad the lawyers, make them file an application for additional evidence, get him admitted, get him evaluated from NIMHANS or from some experts, get their reports. On that basis, we'll try to award the compensation. And to meet such contingencies, the simple answer would be, I think from now onwards, the book of Sharan Patil and Pratibha Patil can be made use of by all the stakeholders, judges, lawyers, doctors, everybody. As we release this work today, we must continue to reflect on whether our legal doctrines, institutional practices, and educational frameworks are keeping pace with knowledge. Justice is not static. It evolves as our understanding evolves. It is like a flowing river. It takes its color, shape, depending upon the terrain it travels. Ultimately, a justice legal system is the one that listens carefully, learns continuously, and decides wisely. That is the aspiration that underlies this work. I congratulate all those who have contributed to it and wish the Neuro Justice Trilogy the impact and reach its truly deserved heights. With this, I thank the organizers once again and take leave of you. Thank you. Jai Hind, Jai Karnataka.
Thank you so much, sir. Your address has given enduring meaning to the ideas of neurojustice and to the conversations we hope will continue beyond this gathering. As we move towards the close of today's program, it is important to recognize that initiatives such as this are never the work of one individual alone. They are shaped and sustained by collective efforts of many with quiet passion and commitments behind the scene. We would like to express our sincere gratitude to all those who have contributed to the Neuro Justice Trilogy and Handbook. May I now request Honorable Justice R.V. Ravindran, sir, to please distribute certificates to the contributors of the book. I request the contributors to kindly come forward as their names are being announced. Advocate Chetna Konetota. Even with a demanding professional schedule, she made time to carefully review the books, ensuring their legal correctness and integrity. Thank you, ma'am. Bhavyajit Singh. Thank you for helping us despite our really tight deadlines. Followed by members of PRS Neurosciences who have contributed to the book: Atira, Bharatraj, Jyoti Priya, Ravi Babu, and Sona Mol. May I now request Honorable Justice Arvind Kumar Sir to please continue the certificate distributions. Ganapati, Nikhil, Sneha Hari, Stafford Michael, Yashashwini, and Sapna. May I now request Sneha Hari to deliver the vote of thanks.
Respected Chief Guest, respected President of the function, honorable judges and dignitaries on the dais, esteemed speakers, guests of honor, distinguished invitees, colleagues, media, ladies and gentlemen, good afternoon. On behalf of PRS Neurosciences and Mechatronics Research Institute and Rebooting the Brain, I, Sneha Hari, extend my heartfelt gratitude to everyone who's made today's Lokarpana meaningful and memorable. First and foremost, we thank our Chief Guest, Honorable Justice Arvind Kumar, Judge, Supreme Court of India. Your presence gave national relevance and moral authority to the Neurojustice movement. Thank you for your address and for endorsing the need for scientific clarity and dignity in disability assessment. We sincerely thank the president of today's program, Sri Dinesh Gundrao, Honorable Minister for Health and Family Welfare, Government of Karnataka. Your support strengthens the public health and governance relevance of neurojustice and encourages us to move from concept to implementation. We express our deep respect to Honorable Justice R.V. Ravindran, former Judge, Supreme Court of India, for releasing the new Rebooting the Brain podcast promo and for your valuable insights. We thank Shri Rudra Palamani, Honorable Deputy Speaker, Karnataka Legislative Assembly, for reinforcing that neurojustice must reach policy and public systems. We thank Honorable Justice A.V. Chandrasekhar, former Judge, High Court of Karnataka, for presenting the work and purpose of Swasthya Arogya Foundation Trust and for your steady guidance. We thank Dr. V.D. Sinha, President-elect Asian Australasian Society of Neurological Surgeons, for bringing a global perspective to this movement. We thank Dr. Manas Panigrahi, President, Neurological Society of India, for strengthening the clinical and scientific foundation of neurojustice. We thank Shri Seemant Kumar Singh, Commissioner of Police, Bengaluru, for your reflections on law in action and the real interface between behavior, safety, and justice. We thank Padma Shri K.Y. Venkatesh, Paralympian and Disability Ambassador for PRS Neurosciences, for representing resilience, dignity, and lived truth, the core of neurojustice. We thank Senior Advocate Vivek Subbareddy, President of Advocates Association, for your thoughtful video message and for engaging the legal fraternity. A special and heartfelt thanks to the authors Dr. Sharan Srinivasan and Dr. Pratibha Sharan for creating the Neurojustice Trilogy and the handbook and for carrying this interdisciplinary vision with courage and rigor. We extend our sincere thanks to Honorable Srimati Justice Ratha, Director of KJA and the Karnataka Judicial Academy for your continued support. We thank Kumari Chinmayi Pradeep for the invocation. We acknowledge with gratitude all contributors recognized during the certificate distribution. Our heartfelt thanks to the organizing committee, volunteers, and support staff for their committed efforts. We also thank the High Court judges who have come to this event and for gracing your presence with this occasion. Special thanks to Microknowledge Academy for your unwavering support. We also thank Torrent Pharma, Sun Pharma, Intas Pharma, and Cellagenix Research India for their support. We appreciate Athena Legal, Perez Consulting, Sheetal Printers, Arc Stellar, NIMHANS, and the Skyline team. We also thank all the media and press for amplifying this message. Most importantly, we thank every delegate and guest present today. Your presence strengthens our shared belief that when science, law, governance, and humanity meet, we can build systems that protect dignity and deliver justice. With these words, I conclude the vote of thanks. Thank you all. May I now request everyone to kindly rise for the national anthem.
शुभ नामे जागे तव शुभ आशीष मा